లోపల ಬನ್ನಿ ಸರ್, ಬನ್ನಿ ಕೂತ್ಕೊಳ್ಳಿ. ಒಳಗಡೆ ಇದ್ದಾರೆ, ಕೂತ್ಕೊಳ್ಳಿ. ಇವತ್ತೊಂದು ಕೂತ್ಕೊಳ್ಳಿ ಕಡೆ. ಎಂಟ್ರಿ ಆಗಿದೆ, ನಾನು ಫುಲ್ ಎಂಟ್ರಿ ಆಗಿದೆ. ನಾಳೆ ಹಾಕ್ಬಿಡೋಣ. ಹೊಸ ತೆಗ್ಸಿದ್ದ ಅಷ್ಟೊಳಗೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ರು ಅದಕ್ಕೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟಲ್ ನಂಬರ್ 20, serial number 1, cause list 1.
ಅವ್ರಿಗೆ ಎಷ್ಟು ವರ್ಷ ಈಗ ಇವ್ರದ್ದು ಮಗಳದು ಮಗಳಿಗೆ ಎಷ್ಟು ವರ್ಷ
Court officer?
No, he's not court officer.
Huh?
He's not court officer.
He's not court officer, I know.
You want?
All 20 proceedings. It has noted. It is. Let this code all 20 proceedings, let it be like this only.
Yeah. I'll mute it.
Matter to be listed tomorrow. Your Lordship may kindly recollect matter where Your Lordship had directed the mother to come from Gwalior to bring the child along with her to enable the father and grandparents to have visitation. From October, there's been complete violation of the order.
It's already closed, I think.
Only modification is what I've done. To permit, instead of her coming around, I will go and pick up the child and come back. That's all I'm seeking. I'm only seeking modification of the order. I filed an application, also served the copy on the other side.
We'll see. Let it come next week.
On Monday,
Please.
or on after Shankranti on Wednesday, 15th.
No, let it be on not 15th. Let it be on 20th. January 15th.
20th.
Yes.
I'll go. 20th, I'm not in station.
21st.
20th. Obliged. Obliged.
Yes. When do you want? When do you want? After? Let's this matter on 22nd at the request of learned counsel for the petition. Have you informed the other side? You have you informed? Not will. Then please wait till your turn. Yes, call the matter.
That's 24 and for the petitioner.
Yes.
1 week's time.
Why? Inform the other side.
I met him.
No. The rule is that you have to inform and then make a mention. No, I will. You have to inform by the time you mention. Yes.
41. I'm for the petitioner. I've informed the other side. Only take it up, my lords, in the next week. So Satish Chandra, my lords, I've informed him.
2018 matter. Why?
Monday, my lords. But some difficulty today.
This on Monday at the request of learned counsel for the petitioner.
Great.
Yes, call the list.
My lord, a small apology. I'm seeking for a little accommodation. Reason is, I have searched all the decisions. There are few decisions in favor and also few decisions where there is
Every clarity on the judgments about however rescission
Yes.
of the contract.
where there is no mention of specific date or period. There is ambiguity, and also the Supreme Court has clarified it. those decisions, I will place it. And the second reason why I'm seeking is, now, so far as me is concerned, one of my brother-in-law is for transplantation of this heart, he is in the hospital. So at least till Monday, I may request.
Yes, yes, that is not a problem.
Yes, if it is accommodation is given on 20th, my lord.
Oh,
So
yes,
that
20th, list on 20th.
is a very short point where I can.
The same caption on Saturday at the request of learned counsel for the respondent.
Publish, my lord.
There is an interim order.
Interim order extended till then. Yes.
For the petitioner, my lord. I'm challenging the order dated 15/12/2017, my lord. Yesterday I heard the matter.
These
Respondent.
are papers. Yes. Yes.
My
Not-
lord. In this case, my lord, the suit for recovery suit filed by the respondent, my lord.
You are for the respondent?
Fine.
Yes.
Fact, the suit is dismissed against the LIC of India.
Suit is?
Dismissed against the LIC of India. In the contested document, have one more part.
1 to 3.
Huh?
One, my lord, one.
Only one.
The respondent number one is Shivanna.
Shivanna is contesting
He's the
respondent, my lord.
contestant.
You are representing?
4 and 5, LIC of India.
4 and 5.
Yes.
Yes.
My lord, the suit is filed by the respondent for recovery of amount 8,20,000, my lord. First, check bounce case was filed by the respondent. At the time, issuance of notice, the complaint accused was died. The case, check bounce case is dismissed with liberty to file recovery of suit. On that basis, the recovery of suit filed. The recovery suit filed and ex parte order was passed, my lord, without serving the notice and without intimation or nothing to the complainant accused legal heads.
The petition filed under order 9, rule 9 of the CPC is allowed.
Yes, my lord.
Petitions are directed to deposit the decretal amount as per the directions with interest on or before 12/1/2018. Then the office is directed to place the records before the court.
Yes. That order is challenged by me by filing miscellaneous petition, my lord. The miscellaneous petition is dismissed for non-prosecution, my lord, because
How many times it will happen? Step one order, again is that, again you will question it, another order will be passed. You will question it by way of an appeal, again that will be dismissed. So what are the bona fides of
My lord.
of your client in pursuing the matter?
no, my lord, I am a legal head. I don't know any legal knowledge, my lord, because I'm uneducated. The legal heads of the one diseased person. I'm not having any knowledge and I'm not served any of the notice. When they come for execution, that time only I came to know OS order, my lord.
Then
That
what you
order
do?
is challenged by me.
So once you have
af-
challenged, now you don't say that you
Yes,
are an
ma'am.
illiterate, you don't know anything, that is not a excuse.
Yes, my lord.
Then after that, when an order is passed, again is that, and when you filed a miscellaneous, again why it got dismissed for default?
At that time, I could not meet
No,
the
so-
advocate and I'm not given instruction.
All these grounds,
Because
where
my
is
lord-
that order? Please tell the court,
Please,
please
my
that
lord.
order, page number,
Page number, annexure, page number 50, my lord,
page number.
14 and 15.
50.
No, the courts have no other work, but to hear your client's miscellaneous applications, one after the other. Where is the, so where is the?
56, my lord, operative portion of the order is 56. Today is also petitioner remained absent and even there is no representation for the petitioner through this case is called twice. It appears that petitioner is not interested in prosecuting this case. Therefore, no ground to adjourn the matter. Again, for petitioner evidence, in spite of repeated opportunity given, the petitioner has not availed opportunity. It appears that he has no interest in the matter and not interested prosecuting the case.
Yes.
Hence, court is
I don't
passed.
see any grounds to
No, my
set
lord.
aside this order.
Because first of all, the deceased person has not received the
Don't
money.
tell
my lord.
about the deceased person after the deceased, that story is over.
Yes,
After the story, you have filed a miscellaneous.
yes,
That was allowed on condition. Against that, you prefer an appeal. That will be dismissed for default.
my lord. Because
That lapses will not consider.
no, my lord. One opportunity, my lord, because the petitioner is a lady and we
So now
don't.
you will deposit the entire decretal amount. We'll grant you the time.
I'll deposit 25%, I will deposit and
No,
I
when
will
is the decree? When was the decree passed?
decrease in 2014, my lord.
2014 decree. No, they can't, till 2024, it is now, the case is languishing in the courts. No.
I'll
Please come.
deposit 25%, my lord,
No.
and I'll contest the case, my lord, because on merits, they have not shown any merits while taking the order, my
This is
lord.
not the way.
The
the courts
OS
will
order is
interfere.
itself ex parte order.
That's
my
not the
lord.
way how the courts will interfere in these
No,
kinds.
I'll
of matters.
deposit 25%, I'll show my bona fide and I'll contest the matter in trial court, my lord.
Apart from
One
that, I'll-
opportunity may be
and
given. my
Apart from that, I'll impose exemplary costs if that has to be done.
lord.
No. It can't be.
No, my lord.
This is
No.
not the way how a
The-
litigant can be permitted to pursue the litigation.
No, petitioner is already in huge trouble, my lord.
Let
There
him be.
no source of income, my lord,
Let him be, let him be.
because
All the more
only
good.
she is surviving on.
No, all the more good. You have no money, you cannot pay. Let whatever, even if the decree is
Yes.
executed, nothing can be recovered. Why are you bothered?
Is surviving on whatever the benefit coming from the deceased person. Apart from that, nothing is
Court
there. my
cannot
lord.
exercise a discretion in favor of these kind of litigants who are taking the course of the procedure for a right.
No, on humanitarian ground, one opportunity may be given, my lord, because I have not contested the matter anywhere. I am not grant any opportunity, or I'm not utilized the opportunity, whatever the court is
What
granted.
opportunity? I'm not able to understand. What opportunity, please tell the court?
Because my lord, OS is ex parte order, my lord.
Yes, it's ex
Notice is
parte.
not served if.
OSC is ex parte, that I can understand.
Yes,
Then
ma'am.
after that, you file a miscellaneous.
Yes.
An order is passed. You prefer an appeal against that, miscellaneous against that. You don't pursue the matter. And the court records that continuously you're being absent. Then why should an order, a judgment and decree that is passed by a court in the year 2014 shall not be executed till 2024? That is, your client thinks that you can take the course for a ride.
No, my lord.
I'll not. Either you
I-
deposit the entire amount or whatever, for depositing the entire amount, this has to go because the order of the miscellaneous will hold good. For even on that count also, this has to be dismissed.
2 days time may be granted. I'll seek instruction from the.
Yes, Friday. This is
My
matter on
lord,
Friday.
Monday, my
Third.
lord. My lord, Monday, Friday, my personal inconvenience.
Monday, not Monday, post on Wednesday.
Much obliged.
Cell number 3.
No, not Wednesday, Thursday.
Kindly pass over, my lord.
Cell number 3.
Senior is held up in Kotal 4.
Appear for the respondent number 1. Rashina JD, PN Harish, respondent number 1.
Appearing for petitioner, my lord.
Hmm?
On record counsel is held up in Kotal 4. Instructed me to take pass over, my lord. Kindly
Hey,
pass.
everybody's instructing you to take pass over in all the cases. Pass over next.
Cell number 4.
Matter still not yet listed before the apex court is my instructions.
Respondent may be, please.
Huh?
Matter has not been posted before the apex court is my instructions.
Yes, please, your lordship. Meanwhile, the parties are also trying to mediate amongst themselves.
When do you want?
Now, please, your lordships.
When do you want? When do you want the matter to be listed
Four
again?
weeks, accommodate.
List this matter on February 10th.
Please.
Obliged, lords.
For dismissal, cell number 5.
For the petition, the process has been taken, needful done has been done, Madam.
Then counts for the petition submitted, the needful is done.
But
Then what about number 2?
I will comply it here, the full cast title has been taken out, my lordship, I will comply it here itself.
And the office of objection with regard to the cost title, it is submitted that it will be complied with during the course of the day. list this matter on Friday.
Cell number 6. Rashid Khan for petitioner. Srinivas Murthy.
Give that order, the order sheet. This is a writ petition of 2018. And even till today, the process is not completed. The matter is listed before the court for orders on 6/1/2025. As there is no representation, the matter was listed today. I was directed to be listed today and the caption for dismissal. Today also, there is no representation. It appears that the petition is not interested to pursue the matter. The writ petition is dismissed for non-prosecution. Yes, 7.
Cell number 7. Subhash Shelgar for petitioner. Sandeep Patil.
Number 2 and 3 in this case. We have filed NOC Vakalat, but even then our name is being reflected in the cost right.
You're for the respondent or the petitioner?
2 and 3. Respondent number 2 and 3.
Yes. A writ petition of 2018 is listed. For, as the petitioner has not furnished the PF for issuance of notice to the respondents. As there was no representation on the last occasion, this court has directed the matter to be listed in the caption dismissal. Same order. Yes, next.
Cell number 8.
Petitioner
in the
other case.
My lord, I represent the petitioner in this one matter, my lord. My lord, I am told, my lord, the matter has been settled among the parties. My lord, I will ascertain and submit within 2 days, my lord. Time may be granted, my lord.
Yes, yes, madam.
My lord, I don't know that instructions, my lord.
That's fine, my lord.
List this matter on Friday.
Very well, my lord.
Monday, my lord. Could it be on Monday, my lord?
Let it be on Friday, next Friday.
Grateful, my lord. Great.
List this matter on Friday. Delete from the caption for dismissal.
Cell number 9. Danappa P. Pani Bhatte for petitioner. Tish.
Yes.
Tej.
Writ petition of 2018. See,
Cell number 10.
dismissal, non-prosecution is
10.
For petitioner.
Terms.
Applied, yeah, my lord.
Done.
applied.
Complaint.
The land council of the petition submits the needful is done. List after service of notice delete from the caption dismissal. Yes,
Cell
11.
number 11. 11. Siddesh for petitioner.
Give that. And there is no representation. Same on 6/1/2025, the matter was directed to be listed today. Or the caption for dismissal, no representation, dismissal, no prosecution. Next 12.
12. SN Bhatt for petitioner.
Same, non-prosecution. Same order in all the matters. Yes,
Cell number 13. Nagaraj.
11 in terms of process. 13, as there was no representation, the matter was directed to be listed under the caption dismissal. Today also there is no representation. Yes,
Cell number 14. Cell number 14. Ishad Ahmad BM.
same 2019 process dismissed.
Cell number 15.
No representation on 6/1/2025 dismissed. This is not the process. Look at it. Yes.
Cell
16,
number 16.
is also no representation on 6/1 dismissed.
Cell number 17.
I am appearing for petitioners in this case, my lord. The plaintiffs are report the death of respondent number 3 before the trial court in the last date of hearing. I am filing memo reporting the death of respondent number 3. I pray for time to take steps to bring the of respondent.
Memo is filed stating that there is third respondent. Which respondent?
Third respondent.
Third respondent is no more. And the petitioner. will take steps within 2 weeks,
4 weeks,
within 4 weeks. List this matter after 4 weeks.
obligation.
Yes,
For
delete from the
number
caption for
18.
dismissal. Yes, 18,
18. Vinod Reddy.
same order process.
Yes.
2020 writ petition dismissed for non-prosecution.
For order serial number 19. Government advocate.
No representation for dismissal tomorrow.
Serial number 20.
For the respondent number 7.
Abhinav Ramanan.
Who appears for the petitioner?
Abhinav Ramanan.
Copy of the objections have been served to the petitioner, Manoj. They had also
Found
accepted.
rectification of objections raised on statement of objections filed by advocate for R7.
That is not served acknowledgement, the copy serving acknowledgement has not been.
It is submitted that there is no representation on behalf of the petitioner on the last occasion and even today also. Then counsel, it is under dismissal. The
Order, sir.
order, sir. There is no representation today on behalf of the petitioner. Land counsel for the respondent submits that already they have served the copy on the petition.
Your Honor.
And as such, they have complied with the office objections. List this matter tomorrow.
My lord, for respondent number 7, we have filed the NOC. Still our name has been appeared in the list, so kindly take.
What's your name?
V Gangabai, our senior name has been.
Whose name has to be deleted?
V Gangabai.
Yeah,
Delete
should be
in
deleted.
20.1, delete the name of V Gangabai for R7 and Balakrishna Sastry is appearing. Yes. Next,
Serial number 21. HR Anant Krishnamurthy.
For a week's time.
it's a week's time for complying with the office objections. Or else, same,
20.
default order.
Serial number 22.
Appearing for the petitioner, my lord.
Hmm.
The notice actually is not served.
Take
That-
out, substitute service.
Please, my lord, we'll find necessary applications.
List this matter on 28th of January. By the time application for substitute service shall be filed, or else the petition shall stand dismissed without further reference. Without further reference to the court. Yes,
Serial number 23. Sidmalappa PM.
ಇದು ಕೇಸೇ ನಡೆಯೋದಿಲ್ಲ 89 ಇಂದ ಬರೀ ನೋವು ಕೊಟ್ಕೊಂಡು ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
What is that she's saying?
ಅವ್ರಿಗೆ ಕಣ್ಣು ಕಾಣಲ್ಲ ಅಂತ ನೋವು ಜೋಶಿ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಮಾಸ್ವಾಮಿ.
ಸ್ವಲ್ಪ ಜೋರಾಗಿ.
ಇದು ಸಿದ್ಮಲ್ಲಪ್ಪ ಅವ್ರನ್ನ ಇಟ್ಟಿದ್ದೆ ಈ ಕೇಸ್ಗೆ. ಅವ್ರಿಗೆ ಕಣ್ಣು ಆಪರೇಷನ್ ಆಗಿದೆ, ನಂಗೆ ಸರಿ ಕಾಣ್ತಾ ಇಲ್ಲ, ಬೇರೆ ಲಾಯರ್ನ.
you don't have an advocate?
Yes, she is having an advocate. That advocate has.
Your Honor, my lord, I am appearing for the respondent number 4, my lord.
Eye surgery and he.
I am a purchaser of the suit scheduled property in court action, Your Honor.
No, but if that is the case, from somebody from advocate's office should represent why the party is coming to the court.
ಎಕ್ಸ್ಕ್ಯೂಸ್ ಮೀ ಮಾಸ್ವಾಮಿ, ಬಟ್ ಏನಂದ್ರೆ ಇದು ಪ್ರಾಪರ್ಟಿ ಬಿಫೋರ್ ಕೇಸ್ ಬೈಂಡ್ ಇದ್ದಾಗ ನಮ್ ಬ್ರದರ್ ಹಾಕಿದ್ರು.
Tell her that when she has engaged an advocate,
ಅಲ್ಲ,
she can't
ಆಕ್ಷನ್
come
ಬರಲ್ಲ,
and.
ಏಕೆಂದ್ರೆ ಜಮೀನ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಮನೆ ನೀವೇ ಉಳಿಸ್ಕೊಳ್ಳಿ ಅಂತ ಹಿಂದಿನ.
Yes.
My lord, already I have deposited 25% of bid amount in a FDP number 20/2024, dated 24/7/2017. My lord, please vacate the interim stay order. Your Honor.
ನಿಮ್ಮಗಳು
Even you want only for the petitioner dragon the proceedings, my lord. Kindly vacate the interim order, Your Honor.
ನಾನು ಕತ್ಲೆ ಮಾಡಿದ್ದೀನಿ, ಅವ್ನು ಬಾಳೆಲ್ಲ ಹೆದರಿಸಿ ನಂಗೆಲ್ಲ ತೊಂದರೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್. ಅವನು ತಗೊಳ್ಳೋ ಹಾಗೆ ಇಲ್ಲ ಇದು
ಬೇರೆ advocate ನ.
ಅಡ್ವೊಕೇಟ್ ಇಟ್ಟಿದ್ರೆ 40 ವರ್ಷ ಆಗಿದೆ, ನನ್ ಸಾಯಿಲ್ಲ. ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಇರ್ತೀನಿ, ಆದ್ರೆ ನನ್ನ ಅವ್ರಿಗೆ ಹೊಸದಾಗಿ ಇಡೋದ್ರಿಂದ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಏನೋ ಅಷ್ಟು ಗೊತ್ತಾಗಲ್ಲ. ನನ್ನ ಹೆಣ್ಮಗಳು, ನನ್ಗೆ ಏಜ್ ಆಗಿದೆ, ನಾನು ಕೆಲವೆಲ್ಲ ಪಾಯಿಂಟ್ಸ್ ಇರೋದನ್ನ ನೀವು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಕೇಳ್ಕೊತೀನಿ, ತಗೊಳ್ಬೇಕು ಅದನ್ನ.
My lord, kindly dismiss this.
Please wait, Mr. Counsel.
Sorry, my lord.
ಅವ್ರಿಗೆ ಅವಕಾಶ ಇಲ್ಲ ಮೇಡಮ್.
Cooperating from long time that matters is going on like this only.
List this matter. next week.
Time, namge.
List is on 29, no representation for the advocate. Party counsel for the court. And she has so many grievances. This is matter on
Respondent number 14.
11th of February. Next matter, yes, 24.
Cell number 24, 11th of February ಗೆ ಕೇಸ್ ಇದೆ ಅಷ್ಟರ ಒಳಗಡೆ ನೀವು ಲಾಯರ್ ನಿಮಗೆ
Yes,
24 ಚಂದನ ತರೀಗಾಕೆ
ಅಲ್ಲಿ ಹಾಕೊಳ್ಬೋದಾ ಮೇಡಮ್ ಅಲ್ಲಿ
next 24,
24
no representation.
ಅಲ್ಲಿ ಯಾರನ್ನಾರು ಕೇಳಿದ್ದೀನಿ
Close this matter for dismissal.
ಹಾ
Yes, next,
dismissal
tomorrow.
Cell
Yes,
number
next.
25.
Lordship, serial number
Harish
25,
Bhandari.
I appear for the petitioner, Lordship.
Hmm.
I'll carry out the amendment during the course of the day. With respect to respondent number 1, we have already filed the amended petition. I'll carry out that if I could address the. It's with regard. Yes,
Whether it is listed today,
it's listed for carrying out amendment, Lordship. It's listed for carrying out amendment. I will carry out during course of the day, Lordship.
Okay.
call the police, call the police, call the police.
Ravishankar sir.
Yes. No, you can do it. What
I'll
is
do it
that
during
you
the
want?
course of the day, Lordship.
Why you want it to be listed today, tomorrow?
No, Lordship. I'll do it
Let's
during
just
the.
matter. Later, and consider the petitioner submits that. The officer's objection will be complied during the course of the day. Let's just matter on,
Lordship, if it is passed over, I'll address my arguments also, Lordship.
not today. Let's
Okay.
just matter on, tomorrow. It will come if you're ready. Yes.
Grateful,
Next.
Lordship.
Tomorrow. Cell number 26. Anand Ramke.
I appear for the petitioner, my lords. The needful has been done.
Then council submits the needful is done. List after service of notice.
Interim order may kindly be.
What is the needful is done?
Lords, the
Steps to
notice
be
was
taken in
returning
respect
without,
of unsolved articles.
The
the shara was returning without an acknowledgement. Now we have taken fresh steps,
which item is this?
26.
26 days, steps to be taken in respect of so and
Unsolved.
so. 4 times unserved. What is the
There's
needful?
no acknowledgement that has returned, my lords.
Take
So-
out 26 for substituted service. Petitioner shall come up with appropriate application for substituted service by 21st of January.
Your Lordship's.
Or
kindly-
else the petition shall stand as.
Lordship's kindly, 26.
Yes,
My lord, we have now received the present address that she is in Delhi. Now we have filed a memo also, my lord, regarding the present address and paid process. Because all this while, my lord, the shara was never returning, my lord, the acknowledgement.
that's why instead
Yes.
of all that, take out a substituted service that will
Very
serve
well.
the purpose. Take out file an
Yeah,
application. for
Because
that.
she is now residing in Delhi. So therefore, if I take out substitute service in Bangalore or, my lord,
No,
in
no,
Bangalore.
both take out, no, how will you know that, what is
No, we have got a copy of her Aadhaar card now. Because respondent number 2 is a sister. So she has,
as per the postal, whatever the address that is mentioned before the trial.
yes,
As per that, you take out substitute.
very well.
Yes,
My lord, in addition to the process, I will take out substitute.
the petition shall come up with the appropriate application for substitute service. This is matter on 22nd January. Yes.
My lord, in addition to the process that is already paid
Addition to
today,
the process already paid.
my lord, interim order may kindly be
The
accepted.
model only granted is extended till then. Yes, next.
Cell number
Public.
27.
Yes, 25 intermodal earlier granted is extended till then.
Cell number
Yes.
27. K. Prasanna Shetty for petitioner. Ajit Anand Shetty.
There is a counsel for the petitioner. Non-filing of wakalat in respect of.
R6, my
R6.
lords, I
You for-
notice
you for-
may
for
have,
the
my
R6?
lords, I have appeared for response 3, 5 and 7, my lords.
Hmm.
I have no instructions, my lords, to appear for R6. May I request my lords to issue notice on R6, my lords?
Notice two. Why the court has ordered, directed you to take notice.
Yes,
for
my lords,
R6.
the honorable court had ordered.
Submitted that this council appearing for the respondents 1, 3, 4, 5 and 7 has no instructions. The registry is directed to issue notice to R6.
Grateful.
Yes,
Cell number 28. K. Madhusudan Rao.
Appearing for the petitioner, my lords. The contesting defendant is only the respondent number 2, my lords. Respondent number 4 has remained ex parte in the trial court. So I'll file a memo for dispensation of notice in respect of R4. R2 may be served through substituted service, or will serve it upon the advocate.
Substitute service. Take that memo.
Yes.
A memo is filed. Taking dispensation of notice to R4. The memo is taken on record and notice to R4 is dispensed with. In respect of R2, the petition shall come up with appropriate application for substituted service. This matter on 23rd. If the application is not filed, the petition in respect of R2 shall stand dismissed without reference to the court. Next.
Cell number 29. A. Madhusudan Rao.
Appearing for the petitioner, my lords.
As per the postal Shara, notice to R10 returned as refused, which amounts deemed service of notice. Next, in respect of
In the respect of the other respondents, I'll file 2 weeks time may be given, my lords. LRs on
in
record.
respect, it is stated that the respondent 11 and 13 are no more. And the petitioner, then counsel for the petitioner submits that you'll take steps for bringing the LRs on record within
2 weeks, my lords.
within 2 weeks. List this matter on the same, I think it would be on
23rd.
what is the date?
23rd.
23rd.
Much obliged, my lords.
Yes,
Cell
next.
number 30. CM Nagbhushan.
My lord, for petitioner, my lord, R8 may be held sufficient.
Mhm.
Notice to R8 may be held sufficient, my lords. I've given second bench, it has come as
Use the mic, I'm not able to hear you.
R8, notice may be held sufficient, my lords. It has come as unclaimed Shara, my
Okay.
lords.
Notice to R4. As
R8, my
postal
lords.
R8 returned as unclaimed and is to deem service of notice. This is matter tomorrow.
Please, my lords, interim order may kindly be extended.
Interim order earlier granted is extended. Yes.
On interlocutory application, cell number 31. Sitaram Rao, BC.
I appear for the petitioner, my lords. IA 1 to 3, my lords, is in respect of LR to respondent 1D. I filed the application, my lords. Notice has to go on IA 1 to 3.
IA number 3 notices, IA number 1.
1
In
to
all the IAs,
1 to 3.
Of 24.
IA number notice to the respondents on IA 1, 2, and 3.
Lords,
What is this IA 4?
IA number 4, my lords, is substituted service in respect of R1A.
Give that IA 4.
The address shown here, my lords, is the same as what they have shown in the trial court. In fact, they are the plaintiffs before the trial court.
No, R3 is for substituted service. IA number 4 is for substituted service.
R1A, in respect of R1A, proposed R1A.
The application is for seeking to take substituted service of notice on respondent number 1A, R1A in Samyukta Karnataka Kannada Daily Newspaper, Bangalore edition. The I number 4 is ordered, petition permitted to take out notice and so and so, so and so. Date on or before mentioning the date of hearing as so and so. Ministry is directed to issue the draft publication. Yes.
My lords, next, my lords, is the memo filed by me, my lords, to hold notice to R1C as sufficient. Because it has come back as
Refuse.
unclaimed.
Where is that?
My lords, I have filed memo, my lords. Memo is 5th
Notice
note.
to R1C as per the post, as returned as unclaimed. Hence, it amounts to deemed service of notice. Accordingly, the memo that's filed, taken on record. Next.
Milords, the next Milords memo, Milords, is for reissue of hand summons to the advocate in the trial court, Milords.
In respect of,
The plaintiff only. Only one party is there. I'll serve it on the advocate appearing there.
no. We wanted a substituted service.
Please, Milords. Milords, in the last date, I was asked to take notice as well as hand summons.
No. Who is this respondent? In whose favor this IA4?
IA4 is for R1A.
No, this is for?
R1A to D, there is one advocate in trial court. I'll serve it on him. Additionally,
It is submitted that in addition to this, the petitioner, in addition to this, the petition is permitted to take out notice on the counsel appearing for the respondent 1A to D. 1A to D before the hand summons to the advocate appearing for respondents 1A to D. Yes.
much obliged.
Cell number 32. Yes, Venkat Subbarao.
It's coming up for the first time.
First time, they'll have to be notified, my lord. Yesterday, my colleague did not bring it to my lord's notice. I'm sorry.
Notice.
Notice to the LRs of the.
Notice. Notice on IA number 1, 2, and 3.
That's not interim order needs to be extended.
Interim order earlier granted is extended.
Okay.
Yes.
Cell number 33. 33. Satyanand BS.
No representation for dismissal.
Cell number 34. K. Ravishankar.
Petition.
Rajshekar S.
You are ready?
Senior will be appearing, madam.
Pass over.
Kindly pass over, senior.
Not may request. Pass over instead of pass over, day after tomorrow.
Yeah, is the matter yesterday it has come?
No.
It's not that.
Not. It's the first time.
Day after tomorrow. This is matter day after tomorrow.
Interim order.
At the request of learned counsel for the respondent, interim order earlier granted is extended till then. Yes, next.
I'm sorry.
Cell number
Yes.
35. Anand Krishna Murthy for petition. HR Anand Krishna Murthy. 35.
The petitioner.
CT Parmeshwarappa.
Yes.
Petitioner has filed a suit against the respondents except the state of Karnataka in OS 17,297 of 2004 for a specific performance of the agreement for sale.
OS number?
17,297 of 2004.
Where is state of Karnataka in this?
Added in the writ petition recently. Added by an application. In the writ petition,
How can it be?
I'll narrate the facts. For impleading,
In a revision. In
it
a
was,
petition.
it was allowed. I'll narrate the facts.
Where
Why?
are the orders? Let me just look at it. Let me look at the order. When is, how is it?
Last time on. I'm not executing the decree against the state. It's only a formal part.
Where is? And who represents the other respondents?
That is CT Parameshwarappa for 11 and 12.
Others are not represented.
No representation for the respondent.
AGA is for respondent number
No
4.
representation for the respondents. The respondents 1 to 9 and 13 or so. And no wakalat is filed. R11 and R12 is represented by an advocate. But the R11 and 12 wakalat is filed. but there is no representation on behalf of the advocate. And the AGA for the proposed respondents is also not present. List this matter tomorrow,
Tomorrow, ma'am. That's apparent next week, ma'am.
next week.
Next week.
List this matter on 17th.
Oh.
Yes,
Case number 36. Nanjunda Reddy, Shivakumar V.
The respondent.
no representation. Post this matter for dismissal. Counsel for the respondent is present. Yes, next.
Case number 37 urgent, 38. SK Acharya. K Prasad Hegde for respondent.
No representation. Post for dismissal tomorrow.
Case number 39.
For the petition.
Yes. SV Prakash.
My lord,
Ravi
is
S.
this so?
Vaidya.
Who appears for the respondent? Counsel for the petition is present, no representation for the respondent. List this matter as part heard tomorrow.
Case number 40.
Appearing for respondent.
Appearing for.
Kanarayi Reddy for petitioner.
Appearing for petitioner, my lord. In this case, on 10/12/2016, PLC was filed by the respondent against the petitioner, where they are saying that the petitioner had borrowed 2 crores 40 lakhs from the respondent, but without any document were produced. And this PLC was filed in Andhra Pradesh on Mandal Legal Service Committee. And in the service committee, we have the order sheet were given that the petition has signed without the knowledge that during the committee itself, Lok Adalat only, my lord, accepting that 2 crores 40 lakhs will be paid to the respondent within the 6 months. But after where the petition were kidnapped by the respondent, even we have filed a criminal petition against the respondent, and the still criminal petition is pending. Directly without any procedure, they came directly to produce, were filed execution.
No, please come to the order. Where is the order?
The order sheet.
Where is the important order?
Simplified. My lord, page number 21.
Page number?
21 award by the
This is not the order. What is impugned now? This is an order passed by the Lok Adalat, the Legal Services Committee,
Execution
Malkajgiri,
is still
Andhra District. How can you question it before this court?
That's why we are filed IA in execution petition, my lord. IA was rejected in
Where
execution.
is that IA? Show that order.
Okay. Page number 105, execution petition 2 clause 2018, my lord. 105. Last IA number 8 filed by the judgment debitor under section 47, section read with section 151 of CPC, dated hereby rejected. We are asking for the this
Now, you will question the execution proceedings before the, even that award was questioned before the High Court of Telangana. Thereafter, when it is dismissed, you went to the Supreme Court. Supreme Court has also dismissed. How can you come up with this an application? There is a stay in this case?
Yes, ma'am.
Stay is granted in this case.
Your Honor, I'm, just
Give that,
request-
give that order. Here. Order sheet. Where there is stay, no stay.
Stay in this, no stay, madam.
Come. Agreed with orders passed in execution number 2 of 2018. Orders passed in I number 8 in execution number 2 of 2018. Dated 10/10/2018. The judgment debtor is before this court. It is the case of the judgment debtor that the decree holder has filed the petition before the Legal Services Committee, Lok Adalat bench at Malkajgiri, RR district. And the court has passed the order which comes within the jurisdiction of the Telangana and Andhra Pradesh state. And according to him, the Lok Adalat has no jurisdiction to pass an order. And that is honest in the eye of law. As the said decree, which is passed by a court without jurisdiction is a nullity, he has come up with an application under section 47, read with section 151 CPC to dismiss the petition filed by the decree holder seeking execution that came to be dismissed by the court. The court has observed that against the award that is passed by the Lok Adalat, he had filed WP number 3164 and 3395 of 2018 before the High Court at Hyderabad, and the same was dismissed. Thereafter, he had carried the same to the Honorable Apex Court, and that also came to be dismissed. And the court observes that the court, being an executing court, is bound to execute the decree since the property is situated within the jurisdiction of the court, and dismiss the application. Then counsel for the petitioner has reiterated the very same contentions that are raised before the trial court and also before the High Court in WP number 3164 and 3395 of 2018. And he submits that the court ought to have considered the application filed by him under section 47 of the CPC. Next para, then counsel appearing for the respondent submits that the court had rightly considered all the aspects and rightly dismissed the application. It is submitted that the court, it is submitted that the executing court is bound to execute the decree which has attained finality. Next para. Having heard the learned counsels on either side, peruse the material on record. In an execution petition, petitioner is questioning the legality or otherwise of the award that is passed. In respect to the said award, the matter was carried to the Honorable Apex Court and it has attained finality. And the executing court cannot go beyond the decree, and that issue cannot be decided by the court under section 47 CPC. In the considered opinion of the court had rightly considered all these aspects and dismissed the petition. This court finds no reasons to interfere. Accordingly dismissed. Next, what is next matter?
Same, ma'am. Connected matter, same. It was filed by the wife, madam, against the respondent.
Same order, everything is same.
Yes, madam.
Page number in this 40.1.
Yes.
Page number of the order.
Page number 124, my lord. Execution petition 1 by.
Agreed with the orders passed in I number 5. In execution number 1 of 2018, the judgment debtor is before this court. The judgment debtor has filed an application under section 47 of the CPC as read with section 151 CPC, stating that the execution is not maintainable. The remaining facts will one and the same. Writ petitions are also same
Yes, ma'am.
that are filed before the High Court.
Yes, ma'am.
Look at that order. Writ petitions, I think, are one and the same. Yes, next.
Then number
Yes, ma'am.
41 urgent, 42, Prasanna VR for petitioner. Yes, Rashika.
For respondent, my lords. Sorry, my lords, yesterday I was on my legs in the other court.
For the defendant's writ petition challenging the orders on IA number 3 and IA number 6, my lords. IA number 3 was filed by the defendant under section 69 of the Indian Partnership Act, saying that the suit is not maintainable as the partnership firm was not registered. Whereas, my lords, IA number 6 filed by the plaintiff seeking to amend the plaint so as to delete the name of the partnership firm in the cause title, as well as, my lords, to delete the first para of the plaint where, my lord, it is stated that the plaintiff is a partnership firm and filed a suit in such capacity.
So his IA is allowed, your IA is dismissed.
My IA is dismissed, my lord, his IA is allowed. My lord, earlier, my lord, the same contention was raised by the defendant. And when the matter was my lord, posted for judgment, an application came to be filed seeking amendment of the plaint. The trial court, my lord, allowed the application for amendment and posted the matter for judgment, and on the very same day, my lord, the judgment came to be passed by the trial court, decreeing the suit of the plaintiff. Then, my lord, RA came to be filed by the defendant, in which, my lord, the matter was remanded, holding that, my lords, the stand taken by the plaintiff is altogether different compared to the documents placed on record. Kindly see, my lord, one sentence, my lords, of the judgment of the appellate court, page number 133, my lords. Of annexure J, which commences from 120, the relevant statement, my lords, finding page number 133, my lords. After line number 5, notes, which starts from even otherwise, if the case of this PW1 is taken as an individual case exposed, then the documentary evidence exhibit P1 agreement, P2 receipt, P4 receipt, P5 check. For that matter, exhibit P6 legal notice will have a different meaning altogether. Lord, the very agreement itself will not show that the partnership firm has entered into an agreement with the defendant. The agreement, my lord, I have produced at annexure.
Yes.
My lord, annexure E, my lords, page number 72. Page number 72. Down below, my lords, for Carmel granites and crushers signed by partner. Therefore, my lord, the agreement came to be entered into between the partnership firm, page number, my lord, 72, annexure E.
When is the suit filed?
My lord, suit, my lord, filed, my lord,
2016.
16. My lord, annexure B is the plaint.
When did you file your IA number 3?
My lord, IA number 3, my lord, filed during the pendency of the suit, which has not been disposed of while passing the judgment by the trial court. IA number 3 was kept pending, and IA number 6 came to be allowed.
Let us see, which year, when is the date?
Please, IA number 3 minutes I have produced.
2017.
My lord, annexure.
28 to 2017.
Annexure F, my lord, page number 75.
Your IA for amendment?
14 to 2018.
14 to 2018 was the application number 6, IA number 6, annexure G. My lord, annexure.
Let's see this IA number 6.
IA number 6, please. Annexure G, my lords, page number 79. 79, Annexure G. The amendment sought for in the cost title to delete Carmel Granite and Crushers, Salvador Villa, Chilimbi, Mangalore, and insert the partner Carmel Granite and Crushers, Salvador Villa, Chilimbi, Mangalore, after the word Mangalore Taluk DK in the cost title of the plaint. Then, my lords, to delete para number 1 of the plaint and insert the plaintiff is the partner of Carmel Granite and Crushers. This is filed on 14/2/2018, whereas the judgment came to be passed on the 15th, very next day, 14/2/2018.
Now we will come to the impugned order.
Please.
Page number.
Page number, my lords, 42. 42, my lords, impugned order. My lord, finding is from page number 43, my lords.
Yes.
This is a suit, second para, heard both sides on both applications. This is a suit filed for recovery of money from the defendant. It is also true that the suit is decreed on 15/2/2018. Against the judgment and decree of this court, the defendant preferred an appeal in area number 18 of 18 before the Honorable PDJ, Bangalore, wherein they have remanded the matter to reconsider IA number 6 and also to dispose of IA number 3. After receiving the entire records and after hearing the both sides on both applications, I am of the opinion that the plaintiff had filed IA number 3. That is mistake, my lords. Defendant has filed application. IA number 3, to dismiss the suit as the partnership firm stated in the plaint is not existence. The same was opposed by the plaintiff, but this application was not disposed of while disposing the main matter. It is pertinent to note that this court, before pronouncing judgment, passed order on IA number 6 permitting the plaintiff for amendment and also direct the plaintiff to continue the suit in his individual capacity, as there is no authorization letter to PW1 from the said partnership firm. Moreover, another partner is not included in this suit. Therefore, when the wakalat is filed for the plaintiff PW1 only, then the suit has to be continued by PW1 in his individual capacity. When this observation was made by this court before pronouncing judgment, then it is clear that the suit is represented only by the PW1 and not by the partnership firm. This section 69 of the Indian partnership comes into play only when the suit represented by the partnership firm which is not in existence. The said provision is not applicable to the present case as this suit is not filed and are represented by the said partnership firm, but by allowing IA number 6, it is the suit filed under the individual capacity of PW1 only. Therefore, section 69 of the Partnership Act is not applicable to the present case. As per the direction of the Honorable PDJ, the IA number 6 to be reconsidered. The plaintiff has come up with IA number 6 to delete the word and insert the partner and to delete para number 1 of the plaint. The same was opposed by the defendant, contending that the amendment cannot be allowed at this stage. On perusal of the admission of PW1 in his cross-examination that Carmel Granite and Crusher ಒಂದು ನೋಂದಾವಣಿ ಸಂಸ್ಥೆ ಎಂದು ತೋರಿಸಲು ಏನು ದಾಖಲೆ ಇದೆ ಎಂದರೆ ಸಾಕ್ಷಿ ಶಾಂತರಾಮ್ ಶೆಟ್ಟಿ ಅವರೊಂದಿಗೆ ಪಾಲುದಾರಿಕೆ ಮಾಡಿಕೊಂಡಿದ್ದೇವೆ. ಅದನ್ನು ನೋಂದಾವಣಿ ಮಾಡುವ ಮೊದಲೇ ಸಂಸ್ಥೆಯನ್ನು ಮುಚ್ಚಲಾಗಿರುತ್ತದೆ. ಸಂಸ್ಥೆ ಇನ್ನೂ ನೋಂದಾವಣಿ ಆಗಿರುವುದಿಲ್ಲ. ದಾವೆಯಲ್ಲಿ ನಮ್ಮ ವಕೀಲರಿಗೆ ನನ್ನ ಒಬ್ಬನ ವಕಾಲತ್ತು ನೀಡಿರುತ್ತೇನೆ, ಅದರಲ್ಲಿ ಸಂಸ್ಥೆಯ ಸೀಲ್ ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ವಕಾಲತ್ತನ್ನು ನನ್ನ ವೈಯಕ್ತಿಕ ನೆಲೆಯಲ್ಲಿ ನೀಡಿರುತ್ತೇನೆ ಎಂದರೆ 5 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ನನ್ನ ವೈಯಕ್ತಿಕ ನೆಲೆಯಲ್ಲಿ ನೀಡಿರುತ್ತೇನೆ. ವಾದಪತ್ರಕ್ಕೆ ನಾನು ಸಹಿಯನ್ನು ವೈಯಕ್ತಿಕ ನೆಲೆಯಲ್ಲಿ ಮಾಡಿರುತ್ತೇನೆ. Lord, what he says, the partnership firm is not registered. However, it is dissolved and I have paid the money of rupees 5 lakh on my individual capacity and wakalat is executed on my individual capacity. From this clear admission of PW1, it clearly goes
to the plaint.
Please, notes.
Complaint.
Please, notes. Annexure B, notes. Annexure B. Kindly see constate notes. Carmel Granite and Crushers.
Number.
Page number 47 notes. 47. Carmel Granite and Crushers, Salvador Villa, Chilimbi, Urua, represented by its partner, Mr. Rock Ronald Pinto, aged so and so, so and so. Then, my lord, first para kindly see, my lords, the name and address of the plaintiff. Next sentence, the plaintiff is a registered firm carrying on the business of granites and crushers, and it is having its registered office at Salvador Villa, Chilimbi, Urua, Mangalore, and it is represented by its partner. Now, my lord, the plaintiff wanted to delete this particular sentence and delete the first para of the plaint.
Where is this agreement dated 12/6?
Lord, annexure, my lord, annexure, annexure, E, my lords, page number 72. Page number 72, annexure, E, my lords. That is, the signature is also marked as Exhibit P1D. for
No, the
Carmel
agreement-
Granites
the
and.
agreement is between two individuals.
Yes, yes, document is in between two individuals, but signed for Carmel Granites. That is why the plaint, my lord, was instituted, plaint was filed in the name of partnership firm. Otherwise, my lord, even check is issued by the, my lord, granite firm. And my lord's agreement. That is what the first appellate court, my lords, finds, that the documents speaks all, kindly see I have read the first sentence, my lords. The finding of the first appellate court while remanding the matter. Page number 133. Even otherwise, if the
How-
case.
Why by way of an amendment, you cannot be permitted to take these kind of inconsistent pleas?
No, Manoj. No, kindly see the agreement itself. Agreement is between two individuals. Lord, sir, by virtue
Who
of,
signed the
my lord, sir, the
partner of a
partner of the firm.
and the check is given by the,
Check is insofar as, my lords, that now kindly appreciate one aspect, my lords, here, this, the present suit is one for recovery of money.
but who is the plaintiff is what is matter.
Plaintiff is, my lords, may request my lords to kindly.
No, your entire pleading says
Yes.
that it's a partnership form.
Yes.
Partnership form entered into, and everything and your signatures, everything is on behalf of the partnership firm. You issue a check on behalf of the company. Now, by way of an amendment, that kind of an inconsistent plea,
No, my
now
lords.
your entire case is going to be changed by this. How can that be allowed?
No.
That way the fag end of the trial.
Now, my respectful submission is, my lords, kindly see what is the amendment I have sought for. Lords, kindly turn to page 79.
Then why, then it is like, no, entire your plaint, it is not about just the cost title. It is about everything.
No, my lords, it is only insofar as cost title.
Look
The
at
the
it.
suggestion was made, my lords, at the time of cross-examination of PW1. Suggestion was made, the transaction was individual
The
capacity.
plaintiff is a registered firm carrying on the business of granite, so and so. If it is individual, on an individual capacity, why did you give a
Now,
check of
may
the?
I request my lords to kindly turn to page 80 for a minute. Page 80, affidavit, what I have stated in my affidavit. 80, my lords. Para 2. I say that I was one of the partner of Carmel Granites and Crushers.
No, that is not by way of an affidavit. You might say 100 things. What you said in the plaint is what is now.
Plaint,
we have to look at.
even in the plaint, may I request my lords to kindly turn to the plaint also, my lords, for a moment. The plaintiff and the defendant entered into an
I can
agreement
understand.
dated, so and
If
so.
the agreement, which is the basis for you to say about all the basis for the transaction, there if it is as an individual, as a individual, if you have signed, and the check is given as an individual, that we can understand.
No, now that is what is the issue, my lords. That's why I may request my lords to kindly see the agreement also for a moment, my lords. Agreement available at page 73.
Oh.
Last paragraph.
Hmm.
73, last paragraph. A sum of rupees 5 lakhs has been paid by the second party. Second party is, my lords, individual, Rock Ronald
Then
Pinto.
in that fact, this agreement itself is honest because a party has not signed it. There is no
Lords,
agreement.
That is why I requested my lords to kindly turn to page 72. Individual name, my lords,
Correct.
at serial number 2.
There are two names,
Yes.
individual names.
Yes.
That individual has not at all signed.
No, but kindly
There
see
is no
further,
concluded contract here.
further, my lords, in serial number 2.
What's the
Serial number 2, Rock Ronald Pinto,
Yes,
son
that
of
I
so and
see.
so.
Where is Rock Ronald Pinto's signature?
My lords, kindly further, my lords, on the 4th line. Partner Carmel Granites and Crushers. Now, this is what is, my lords,
In the capacity of a partner you did?
of a partner, partner so and so, so and so. Now, kindly see the cost title for a minute, lords, in this plaint. Kindly come to.
Before we going there, please tell the court, now you have entered into agreement as Mr. So-and-so.
Yes.
When it
Partner
comes to
of.
the signature, you have signed as a partner of so-and-so, but not as Rock Ronald Pinto.
My lord, sir, he was represented as partner of this Carmel Granites and Crushers.
Either ways, it has to be taken as even that the stamp paper is also purchased. Caramel Granite and Crushers.
Crushers.
So how can you take by way of an amendment this kind of a stand? How
Now,
can all your admissions, all your things can be taken away by this amendment?
That
How
is
can
why-
it-
that
why
is
should
why-
it be permitted?
that is why I have requested my lords to kindly see what is the amendment now I have sought for. Only to incorporate the name which was found in the my lord's agreement, nothing else. That is why I have requested my lords to kindly see page 72 for a moment at serial number 2. And now by virtue of amendment, kindly come to page 47 for a moment. This is all I have sought for. Instead of my lords filing the suit in the name of Rock Ronald Pinto, so and so, partner of Carmel Granites, the initially plaint came to be filed in the name of Carmel Granite and Crushers. Now, by virtue of amendment, we have sought to delete this particular 3 lines, saying that so and so represented by a partner of so and so. That's all we have sought for. Notes, I would like to place reliance on one decision, my lords, which says if it is a misdescription, my lords, then there is no,
It is not misdescription.
my lords,
Entire averments of your claim, and entire basis for the recovery is based on some agreement which you have entered into.
Yes.
And you have entered into the agreement as a partner, not on your individual, because you signed like that. Either that should be wrong or this should be wrong. Though it is mentioned as a Ronald so-and-so, but you sign as a partner, you give the check as a member, as a partner, one of the partners of the partnership firm. No, just like that, it cannot be changed.
my respectful submission is, my lords, it will not change the nature of the suit.
It will, because no, that firm itself is not in existence.
Yes.
And how do you recover the money that is given by the firm when a firm which is not
That is why,
registered?
that is why I request, that is why I requested my lords to kindly see the agreement for one more time.
That I have seen. You are shown as party 1, party 2.
Yes.
But party 2 has not at all signed.
Party 2,
You are not signed as an independent person. You signed as a partner of so-and-so. You
Yes.
purchased the stamp paper as so-and-so partner. So that firm can only sue.
lords, my
That firm is not in existence.
My lords, my respectful submission is, my lords, at the time of executing this, the entering into this agreement for quarrying and granite itself, this particular firm was not in
Then
existence.
why did you do it? Why did you enter?
That is
into
why this name, my lords, second name is mentioned as Rock Ronald Pinto, partner of so and so.
We can write 100 things. Ultimately, who will sign?
Signed
That
is,
is
my lords,
binding on the parties.
signed is,
Which party? So there is no agreement at all. If that has to be taken, a party has not signed. You are signed not as an individual. You signed as a partner of the company.
ultimately, my lords, the payment was made in the individual capacity.
So
Yes,
he says that the payment is also made in the name of the company.
second part,
Second
part,
para.
page 73, last para. A sum of rupees 5 lakhs has been paid by the second party.
No, now the whole, that's a whole thing.
Yes.
Who is second party?
Second party
Second
is
party who is mentioned, second party who signed.
Rock Ronald, my lords, is the
No,
second party.
party who mentioned it, no. First of all, this agreement for quarrying, or how is it executable?
Yes, sir.
Somebody is mentioned there, somebody is, the signatory is somebody else. Where is the contract?
That is so far as merits of this suit.
No, not the merit. Now, this is a crucial point. How can you be permitted to amend it when that goes to the root of the matter?
My
That
lords,
at the fag end of the trial,
my
a party cannot be permitted to take away his
lords, the reason why the present application was filed is their own cross-examination. In the cross-examination, my lords, I will translate
you
that.
can't be permitted to, cover up your latches by way of an amendment.
No, my lords, that is why my learned friend read it, which is there in Kannada, my lords, I'll translate it. Lords, may request my lords to come
Which
to page
page?
44.
Yes.
In first 3 lines, my lords, Carmel Granite and Crusher, one the Nondavane Samsthe and Torisal, what document you have to show that it is a registered document? This was the question. For which witness says that we have made a partnership firm in the along with Shantaram Shetty. However, the said firm was closed even prior to the registration. This was the evidence. Then
It's all the more a worst case.
I cannot, my lords, improve what I have, my lords. Samsthe innu nondani agirudilla. That means, my lords, the firm is not yet registered. ದಾವೆಯಲ್ಲಿ ನಮ್ಮ ವಕೀಲರಿಗೆ ನನ್ನ ಒಬ್ಬನ ವಕಾಲತ್ತು ನೀಡಿರುತ್ತೇನೆ ಮತ್ತು ಅದರಲ್ಲಿ ಸಂಸ್ಥೆಯ ಸೀಲು ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಐ ಹ್ಯಾವ್ ಗಿವನ್ ವಕಾಲತ್ ಇನ್ ಮೈ ಇಂಡಿವಿಜುವಲ್ ಕೆಪಾಸಿಟಿ ಅಂಡ್ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಗಿವನ್ ಎನಿ seal of the firm. Then my lords, ಆ ವಕಾಲತ್ತು ನನ್ನ ವೈಯಕ್ತಿಕ ನೆಲೆಯಲ್ಲಿ ನೀಡುತ್ತೇನೆ. I have given it in my personal capacity. And I have paid 5 lakh rupees in my personal capacity. And I have signed the plaint in my personal capacity. This was the evidence.
This is one aspect.
And
What do you say about on his application under section 69?
69 is with regard to my lords, the contention is that, my lords, the particular partnership firm was not in existence as on the date of,
Admitted by
my
you.
lords, as on,
It's admitted by you.
that is where, my lords, the
whole crux is.
whole crux lies now. Now, my lords, admittedly, as on the, I cannot, my lords, go beyond the evidence. My lords, admittedly, as on the date of signing the particular agreement, my lords, partnership firm was not in existence. My respectful submission is, my lords, just because, my lords, the partnership firm was not in existence, that will not take away my right to recover the amount for having my
On
lords,
your independent this thing, now with all these plaint and all, if it is, everything is within the limitation, then you might be doing
my
it.
lords, now in view of this, my lords, the issue of limitation also will come, my lords. However, my
come.
lords, I'll try to place reliance on one decision, my lords.
Please. No, because your client is in, was in a fix, because the agreement is entered on behalf of like, he signed as a partner.
Off the record, my lords, now the practical problem what we advocates are facing is, my lords, the agreement was signed. My lords, the name was mentioned as individual, signed as partner.
Partner.
This is where,
So
my
you
lords,
had to file a suit in the name of the firm. Take that, take that.
that's para 6, 7 and 8, my lords, of this particular judgment, of course, old judgment, my lords. Similar issue was before the on the.
Let's read it.
Yes.
Yeah.
Para 16. This court considered in a somewhat similar case in Purushottam Umed Bai case. A firm carrying on the business outside India filed a suit in the firm name in the High Court of Calcutta for a decree of compensation of breach of contract. The plaintiff then applied for amendment of the plaint by describing the names of all the partners and striking out the name of the firm as the mere description. The application for amendment was rejected on the view that the original plaint was no plaint in law, and it was not a case of misnomer or misdescription, but a case of a non-existent firm or a non-existent person suing. In appeal, the High Court held that the description of the plaintiff by a firm name in a case where the Code of Civil Procedure did not permit a suit to be brought in the firm name should properly be considered a case of description of the individual partners of the business, and as such a misdescription which in law can be corrected and should not be considered to amount to a description of a non-existent person. Against the order of the High Court, an appeal was preferred to this court. This court observed, since however a firm is not a legal entity, the privilege of suing in the name of a firm is permissible only to those persons who, as partners, are doing business in India. Such privilege is not extended to the persons who are doing business as partners outside India. In their case, they still have to sue in their individual names. If, however, under some misapprehension, persons doing business as partners outside India to file a plaint in the name of their firm, they are misdescribing themselves as the suit instituted by them, they being known collectively as a firm. It seems, therefore, that a plaint filed in a court of India in the name of a firm doing business outside India is not by itself a nullity. It is a plaint by all the partners of the firm with the defective description of themselves for the purposes of Code of the Civil Procedure. In these circumstances, a civil court could permit, under the provisions of Section 153 of CPC, or possibly under Order 6, Rule 7, about which we say nothing, an amendment of the plaint to enable a proper description of the plaintiffs to appear in it in order to assist the court in determining the real question or issue between the parties. These cases do no more than illustrate the well-settled rule that all the amendments should be permitted as may be necessary for the purposes of determining the real question in controversy between the parties, unless by permitting the amendment, injustice may result to other side. In the present case, plaintiff was carrying on business as commission agent in the name of so-and-so. The plaintiff competent to sue in his own name as manager of Hindu Undivided Family to which the business belonged. He says he sued on behalf of the family in the business name. The observations made by the High Court that the application for amendment of the plaint could not be granted because there was no averment therein that the misdescription was on account of a bona fide mistake, and on that account the suit must fail, cannot be accepted. In our view, there is no rule that unless in the application for amendment of plaint, it is expressly averred that the error, omission or misdescription is due to bona fide mistake, the court has no power to grant leave to amend the plaint. The power to grant amendment of the pleadings is intended to serve the ends of justice and not governed by any such narrow or technical limitation. Since the name in which the action was instituted was merely a misdescription of the original plaintiff, no question of limitation arises. The plaint must be deemed on amendment to have been instituted in the name of the real plaintiff on the date on which it was originally instituted. My lord, sir, I can understand if this particular pleading was taken, my lords, in the written statement. There was no pleading to that effect, my lords, in the written statement. In that way of the matter, my respectful submission is, my lords, this amendment will not take away, my lords, or it will not prejudice the interest of, my lords, the defendant. Per contra, my lords, if amendment is not allowed, my lords, I will be prejudiced and affected is my respectful submission. I can understand, my lords, if it changes the entire nature of the suit, my lords, then he is right in contending.
That's what happened.
My lords, now virtually the relief sought for in the plaint remains, my lords, recovery of suit. Whether plaintiff as a firm is entitled or, my lords, as an individual, that is up to the trial court is my respectful submission, my lords. On merits is my respectful submission.
Please come. Agreed with orders passed in I number 3 and I number
3 and 6.
I number 3 and 6. 3 and 6 and OS number 85 of 2016, dated 15 to 2018. The defendant is before this court. The respondent herein has filed a suit for recovery of money and as the partner of Caramel, Granite and Crushers, represented by the plaintiff as its partner. It is a case of the plaintiff that he has, there was an agreement between the plaintiff and the defendant for quarrying the granite stones. As per the agreement dated 12th June 2008, it is between Mrs. Anupama HD and Mr. Rock Ronald Pinto, partner of Caramel Granites and Crushers. And it is signed by both Anupama and the partner of Caramel Granites and Crushers. In view of the disputes between the parties, the notice was issued calling upon the defendant to make payment of the amount due to it. And when the defendant failed to return the amount, the present suit for recovery is filed. The suit is of the year 2016. In the year 2017, I number 3 is filed on the defendant under section 69 of the Indian Partnership Act, stating that the firm is an unregistered firm and it cannot maintain a suit. Thereafter, on 14 to 2018, I number 6 is filed seeking amendment of the plaint. Where is that amendment?
My lord, amendment annexure,
G, my lord.
G, my lords, 79, page number 79.
Wherein they sought for an amendment to delete caramel, granite and crushes and insert partner caramel granites and crushers and to delete para number 1 of the plaint and insert the plaintiff as a partner of caramel granites and crushers. It is a case of the defendant that the suit itself is not maintainable as a partnership firm is an unregistered firm. Initially, the application filed by the plaintiff under order 7 to 11 was allowed and no orders were passed on the application filed by the defendant. And the suit was decreed. It was decreed earlier.
Yes. Yes, ma'am.
Against that, the defendant had carried the same by filing a regular appeal. And the regular appeal, the judgment and decree was set aside and the matter was remanded back to the trial court. After the remand, the imputed case passed, whereby the court had allowed the IA number 3, dismissed IA number 3 filed by the defendant and allowed IA number 6 filed by the plaintiff. Next para. Learned counsel appearing for the plaintiff submits that court has failed to consider the application that is filed by the defendant and its proper perspective. It is submitted that when the suit is filed in the year 2016 and after the trial has commenced, or at what stage you filed it?
It was the
Trial commenced, my lords. In the cross-examination, he has admitted that it is not registered. Then I filed an application
In
for.
the cross-examination, when the plaintiff has admitted that it is an unregistered firm, then the defendant has come up with the IA in the year 2017, that is on 28/2/2017. After that, on 14/2/2018, that is exactly nearly after a year, the present IA and order 6 rule 17, that is IA number 6 is filed, seeking amendment of the plaint. The trial court by order impugned
Page 40.
while allowing the IA number 6 and dismissing IA number 3, observes that in the cause title of the plaint, it is mentioned that he is the partner of caramel, granite and crusher. But in view of his clear admission in evidence that the said partnership firm is not in existence, the plaintiff is not permitted to file the suit as a partner of the said firm. On perusal of the agreement and with the clear admission of PW1, it is clear that in the individual capacity of PW1, only he had entered into agreement with the defendant and also make payment individually. Therefore, the plaintiff is not permitted to file the suit or sue the defendant in the partnership capacity, but he is at liberty to sue the defendant in his individual capacity. The plaintiff at the time of entering into the agreement might have entered into the partnership firm, but it does not mean that even after the close of the said partnership firm, he has to sue or proceed with the case under the said partnership firm only. Hence, the court felt it appropriate to allow the amendment, and court has also relied on several judgments of the Honorable Apex Court. And further, when it comes to, and where is that? Where is the discussion with regard to your IA number, which is IA number?
IA number 6.
43, my lords.
IA number
Page number 43, first, second para. This is a suit filed for recovery of money from defendant. The next para 69, section 69 of
The
partnership. Act.
court observes that the section 69 of the partnership firm, partnership comes into play only when the suit represented by the partnership firm, which is not in existence. And the court felt that the said provision do not apply to the facts of the present case, and accordingly dismissed I number 3 and allowed I number 6. Next part. Learned counsel appearing for the petitioner submits that the agreement, as per the agreement, the name of the two individuals is shown. The defendant signed the agreement and in his individual capacity, whereas the plaintiff has signed the agreement in the name of as a partner of the company, and even the stamp paper is purchased in the name of the company. It is submitted that during the course of cross-examination, he has admitted that the partnership firm is not a registered partnership firm. Immediately, he has come up with an application, that is I number 3, that the suit is not maintainable. In spite of that, for almost a year, no application is filed by the plaintiff. And the court, without considering all these aspects, particularly the fact that an application for amendment under Order 6 Rule 17, generally, just like that, cannot be allowed after the commencement of the trial, unless and until the due reasons are given by the plaintiff. It is submitted that the reasoning that is given by the court with regard to application of Section 69 of the Partnership Act is also contrary to law and contrary to facts. He submits that the court ought not to have allowed the IA number 6 and ought not to have dismissed I number 3 filed by the defendant. Next para. Learned counsel appearing for the plaintiff submits that the plaint is signed by the plaintiff in his individual capacity. Wakalat is given in his individual capacity. The money is paid in the individual capacity. He submits that this is just an amendment with regard to the misdescription in the plaint. And whether it is a firm or an partner of the firm, the court has to decide about the amount that is taken and whether whether the plaintiff is entitled for the recovery of amount or not. And these kind of technical aspects cannot be considered. And the courts have to look at the substantial justice to be done to the parties. He relies on the judgment of the Apex Court in case of Jai Ram Manohar Lal versus National Building Material Supply, Gurgaon, reported in 1969, 1 Supreme Court cases, 869. He had relied on para number 6, 7, 8, and 9. Extract all this. Relying on this judgment, then counsel submits that it is just considering the fact that except the cost title, the entire transaction and everything is done by him as an individual, and the court has rightly considered all this and allowed the IA filed by the plaintiff and dismissed the IA filed by the defendant, and no reasons are made out to interfere with the well-considered order passed by the court. Next para. Having heard the counsels on either side, there is a material on record. The undisputed facts in this case are, there was an agreement between the plaintiff and the defendant. The agreement shows that there are the name of the defendant and the name of the plaintiff, that is Mr.
872. Rock Ronald Pinto.
Shows Mr. Rock Ronald Pinto. And it also shows that partner Caramel Granites and Crushers. The stamp paper is purchased with the granites and crushers. It is signed by the defendant and the partner of the caramel granites and crushers. It is crushes. Next part. It is the submission of the learned counsel for the respondent plaintiff that the amounts are paid by the individual. The same is denied by the learned counsel appearing for the defendant that even the amount that is paid is by the firm. When the agreement itself is signed by the partner of caramel granites and crushers, the suit is also filed in the capacity of the partner, the caramel granites and crushers. And when the cease is stand taken by him, and basing on that, as per the agreement, the cost title is shown. In these circumstances, it cannot be said that is a misdescription of the parties in the cost title. And that apart, after the trial has commenced and after an application filed under section 69 by the defendant, nearly after a year, the plaintiff comes up with an application. When once the trial commences and the party wants to amend their pleadings, they have to state before the court that in spite of due diligence, they could not have done the same, and it could not be brought to the notice of the court. Here, from the agreement that is filed and the description that is shown, it cannot be termed as a misdescription. And the judgment that is relied on by the learned counsel for the respondent plaintiff, the Honorable Apex Court has observed that the power to grant amendment of the pleadings is intended to serve the ends of justice and is not governed by any such narrow or technical limitations. While allowing the amendment, it all depends upon the facts and circumstances of each case. A party, but by way of an amendment, a party cannot be permitted to cover up their laches and they cannot take out the defense of the other party. That is not the purpose of Order 6, Rule 17. In the considered opinion of this court, this is not a misdescription of the parties, but that description is based on the agreement of sale and other pleadings. As such, that the plaintiff cannot be permitted to amend the plaint at the fag end of the trial. And the fag end of the trial, even the reasoning that is given by the trial court cannot withstand this legal scrutiny. A perusal of the order shows that at one stretch, page number of the order,
43.
in one para, the court observes that partnership firm is not in existence. The plaintiff is not permitted to file the suit as partner of the said firm. Again, there is an observation that the plaintiff at the time of entering into the agreement might have entered into partnership firm, but it does not mean that even after closure of the said partnership firm, he has to sue or proceed with the case under the said partnership firm. These two inconsistent findings given by the court cannot go together, and the order of the court is not a well-considered one. Accordingly, the order dated so and so is set aside, and I number 3 filed by the IA number.
Six.
IA number 6, filed by the petitioner, filed by the plaintiff is dismissed. And IA number 3, as the plaintiff firm is not a registered firm, IA number 3 is allowed.
Number 43, Virupakshaya PH for petitioner.
Now, in case if my lords, IA number 3 is allowed, suit
has
will
to
be
go.
terminated.
Consequently, the suit is dismissed.
May I suggest this, my lords, now, since the suit is in the fag, my lords, virtually, it's
Or else we'll do this.
IA number 3
No,
may be
What
considered.
we'll do is, IA number, no, it is at the fag end.
Yes,
We'll allow IA
IA number
number, we'll dismiss IA number 6,
yes,
and because that is at the fag end, let the court decide it.
that's right.
That would also serve your purpose.
And even on the basis.
Because
Please.
the same, whatever you have,
Please.
the defense, it would be the same.
That's right.
IA number, IA number 7, IA number 6 is dismissed. And as it is at the fag end, the trial is at the fag end, let the court proceed and decide the main suit itself.
Along with the IA number
Moment the
3.
cross-examination is being carried out, Lord, my application was there. Earlier, Lord, the trial court did not dispose of the said application. Therefore, on the very next day of filing the amendment application, Lord, the court allowed the suit, declared the suit. Therefore, an appeal was filed.
No,
Please.
here it is like this.
Yes,
His application under order 6, rule 17 is allowed.
yes.
In the light of that, the content, the
cannot-
consideration of the consideration of the court will be altogether on a different footing.
Yes.
Now, in the light of the fact, his application under order 6, rule 17 is
Yes.
dismissed. It is all the more, helpful for you because you will get a reasoned judgment and decree.
True, Lords. Of course, Lords, it allows,
Say that.
it allows,
will-
Lords.
IA 3 may be considered along with main, my lord.
IA 3 can be considered by the court along with the main suit. And as this is the suit of the year 2016 and already the evidence is latent, the court shall dispose of the suit itself within 6 months from the date of receipt.
Because,
of the
Lords,
copy.
I may have to lead the evidence. That is the problem I am facing, Lords. I may
Already
have-
his evidence is completed. And when the matter was posted for arguments, my lords, I came up with this amendment application.
Yes, no, it is not his problem.
Creates multiplicity
Now,
of proceedings.
now
That's the
virtually,
problem.
my lords,
The main IA number 3 shall be considered along with the main suit, and the suit shall be disposed of within 6 months from the date of receipt of the copy of the order. Yes, next.
grateful.
Cell number 43,
Lords,
Virupakshaya
hearing for the
PH,
petitioner, my lords.
petitioner Udesh.
So writ petition, my lords, is by the plaintiff, my lord. Suit for partition, my lord.
Disposed of.
Lord, suit for partition, my lords, was filed by notes by the petitioner plaintiff, my lord. In the year 2013, my lords, summons was served, my lords, on the defendant number 2, respondent number 2, my lords.
Suit is of the year
2013, my lord.
2013.
My lords, summons was served, my lords, on the defendant number 2, my lords, who is respondent number 2, my lords, in the year 2013 itself. However, my lords, they file an application, my lords, to set aside ex parte order, my lords, in the year,
Set ex parte.
I'm sorry, my lord.
When he was set ex parte.
My lords, in the year 2013 itself.
Hmm.
My lords, in the month of November 2017, my lords, they file an application, my lords, to set aside ex parte order, my lords. Thereafter, that application is allowed, my lords, by the learned trial judge, my lord, on 29/11/2017, my lord. My lords, on 3/8/2018, my lord, IA number 5 is filed, my lords, if your lordship kindly peruse annexure B, my lord,
IA number 5.
5, my lords. Annexure B, my lords, is the application under section 151, my lords, to permit the defendant number 2, my lords, to file written statement. My lords, along with the application, my lords, a memorandum of facts, my lords, is filed, my lords, by the counsel, my lords, learned counsel appearing for the defendant number 2. My lords, on the very same day, my lords, without even permitting, my lords, providing an opportunity to the plaintiff, my lord, to file his objections, my lord, that application is allowed, my lords.
Objection.
My lords, if your lordship kindly peruse, my lord, the memorandum of,
Filing the written statement after a year.
after 5 years, my lord,
No,
summons
why
is served, my lords, in the year 2013.
You can't count it from there. No, when the court has set aside the ex parte order on 29/11/2017, then he filed it.
In the month of August 2018, my lords, this application is filed, my lord. Along with the application, my lords, memorandum of facts is filed, my lord. in the rule 18, my lords, of civil rules of practice, my lord, it contemplates, my lords, if your lordship kindly peruse the memorandum of facts, my lord,
Where is that?
at page 26, my lord.
Yes.
My lord, the last 5 lines married, my lord. The second defendant was suffering from ill health and was under treatment, due to which he could not contact his counsel and give instructions to prepare the written statement. Further, the second defendant had also lost his mobile phone and lost all his contact numbers, including his counsel. Hence, he could not contact his counsel and inform about his ill health, and hence there is a delay. Subsequently, the counsel for defendant number 2 contacted the second defendant through some other person and informed about the filing of the written statement in the above case. Accordingly, necessary instructions were obtained and written statement is prepared and is herewith filed. My lord, if your lordship kindly peruse, my lord, the impugned order, my lord, at page 46, my lord,
46.
on 3/8/2018, my lords, PW1 present. Defendant number 2 counsel files IA number 5 under section 151 CPC with written statement of D2 in 2 sets. IA allowed on cost of rupees 500, cost paid. Written statement of D2 taken on record for issues. My lord, this order, my lords, is challenged, my lords, in the instant writ petition.
Which one is challenged?
I'm sorry, my lord.
Which order is
My
challenged?
lord, this is the order, my lord, which is challenged. The application which was filed by defendant number 2, my lord, has been allowed, my lords, by the learned trial judge. 3/8/2018, my lord. IA allowed on cost of rupees 500. Without any reasons, my lord, the
Everyone present, defendant
number 2 counsel files IA number 5 under section 151 CPC with written statement of D2 in 2 sets. IA allowed on cost of rupees 500.
According to you, no opportunity is given
My
to
lords,
you to-
no opportunity is given, my lords, and the memorandum of facts.
This is your suit.
This is my suit, my lord.
That's what I'm saying. 2019, we are in 25 now.
My lords,
For this reason.
please, my lord.
By this time, you could have got your relief also.
It is still, my lords, in the stage of cross-examination of PW1. My lord. They're also not proceeding. My lords, they took 5 years, my lord, to come before the.
Anyone, now the written statement is taken on record court and now the suit
lords,
is
that-
going to,
that, my lords,
they're
that-
proceeding it.
That is the order, my lords, under challenge, my lords. My lords,
Why you want it? They have filed the written statement, it is over. That stage is over. Now you're proceeding
my
with
lords,
the.
let the trial court provide an opportunity, my lords. And my lords, with the application, my lords, whatever, my lords, was within the knowledge of defendant number 2, he could have filed an affidavit, my lords.
In this case.
There is no stay, my lords. Now, my lords,
Now, why should we put the clock back to 6 years?
my lords, it is,
Not good for you.
My lords.
Because it's your suit. I can understand you're a defendant.
my lords, it is at this, in this stage, my lords, still in the stage of cross-examination of PW1.
What is it going to,
My
how
lord.
is it going to make a difference?
My lords, because, my lords, for the past 5 years, my lord, when the suit was pending, my lord, the defendant number 2, he is, my lord,
So it
He's-
appears that you don't want to go pursue the litigation at all.
my lords, I want to,
You, for some reason, you have filed the suit and you're just,
my lord, it is the suit for partition, my lords. I want share, my lords, in my property.
let it happen. It is unnecessary, again, giving you an opportunity because there is no stay, the suit has proceeded. When is this order passed? 2018.
My lords, it is in the year 2018. my
Let
lords.
it go on, let it go on. Please come. Agreed with the order dated 3/8/2018, whereby the court had permitted the defendant number 2 to file his written statement on cost of rupees 500. The present writ petition is filed. Land counsel is filed. There is IN dated, docket order dated 3/8/2018 in OS number 8724 of 2013. Next paragraph. It is submitted with the land counsel for the petitioner that he has filed the suit for what?
Partition.
Suit for partition in the year 2013. Notices were served on the defendants and they have not appeared before the court and they were set ex parte. Thereafter, in the month of November 2017, they filed an IA to set aside the ex parte order and the same came to be allowed on 29/11/2017. And even then, they have not filed the written statement. Then on 3/8/2018, they filed an IA and a written statement. And to a written statement, the reasons why they have not filed the written statement within the time. The court by order dated 3/8/2018 has allowed the said IA, IA number 5, filed by the defendant. It is a grievance of the plaintiff that without giving an opportunity to the plaintiff to file his objections straight away, the court had allowed the IA number 5 filed by the defendant, which is contrary to the principles of natural justice. And the court ought to have given an opportunity. He submits that on this ground, the petition has to be, on this ground, the order dated 3/8/2018 needs to be set aside. Next para. When the matter came up on 6/1/2015, the counsel for the petition was present and there was no representation on behalf of the respondents. Hence, the matter was directed to be listed today. Today also, there is no representation for the respondent. As such, this court is proceeding to pass the order on the merits of it. Next part. Having heard the counsels on either side, peruse the material on record. The order impugned is dated 3/8/2018. And after that, the written statement is filed. The trial has commenced. Now it is at the stage of cross-examination of
PW1.
PW1. Now the plaintiff is before this court and it's a suit for partition. In the considered opinion of this court, now again asking the court to give an opportunity to the plaintiff to file the objections to the written statement is not either in the interest of the parties or it is not in the interest of either of the parties. In that view of the matter, this court finds no reasons to interfere. Dismiss. Yes, next.
Till number 44. Nagaraj RC.
44, my lord. Pray for weeks time, my lord.
P. Mahesh.
Yes, she's seeking for time.
Petition itself is not noted down. Because violation of injunction order, my lordship, it is an appealable order. They have filed the writ petition, my lordship.
No, my lord, execution order, my lord. Execution order.
In an execution, my lordship, the court has passed an order for violating the, they have violated the, it is held that they have violated the
Look at it
injunction.
tomorrow. My lord, tomorrow, next week. On the maintainability also, you want a stage there? Yes, my
Stay
lord.
is there, my lordship.
Oh, that's why they'll continue it forever. List this matter on Friday, no further adjournments. At the request of non-counsel for the petitioner. Yes,
Till
46,
number 45.
45.
P. Sidramaya.
Appearing for petition, ma'am. And a plaintiff's writ petition.
Yes,
Appearing for petition, ma'am. That plaintiff's writ petition, ma'am.
yes.
That suit is for permanent injunction. That plaintiff has filed an IA for amendment. IA is at page number 22.
Which year is the suit?
Suit is of the year 2014, my lord. It is stayed by this honorable court.
When did you file the IA?
Well, IA have filed on 11/3/2019.
11?
3/2019.
Please come to that IA application.
Page number 22, my lord. Well, in second page and in para number 3, in the beginning of the third line, to add the sentence, gifted the suit schedule property orally and delivered the possession of the suit schedule property in favor of the plaintiff and, my lord, this needs to be added at page number.
Gifted the suit scheduled property orally and delivered the position of the
Page
suit scheduled
number
property.
13 may kindly peruse, my lord. That is the plaintiff, where I have to add it.
In 2019.
Yes.
According to you, that is not giving instructions to the advocate.
Yes, my lord, registered, we have in page number 3 of the plaint, at page number 13 may kindly peruse, my lord. My lord, it is further, para number 3, page number 13. It is further submit that the above said Asma B is the mother of the plaintiff and she executed registered will in favor of the plaintiff. But my lord, in between, in second line, after and she gifted the property orally by way of hiba, and then she has executed the registered will, that is needs to be added. The evidence has not yet been commenced, my lord. The trial court has rejected the application by coming to the conclusion that the document has not been, sufficient documents were not produced.
Please come to the impugned order.
The finding of the trial court is, so court has to enter into the merits of the case. It is the plaintiff to prove the merits of the case, my lord, at page number 31.
Trial has not commenced.
Trial has not commenced. Issues were framed and posted for evidence. Actual recording of evidence has not been commenced.
Framing of issues is.
No, it is not a commencement of evidence. Actual commencement of evidence starts only after recording of evidence.
Framing of issues is not commencement of trial.
My lord, on record it is a commencement of, but factual recording of commencement of.
We are on,
Yes, yes.
when CPC says commencement of trial, commencement of trial. Or
No,
how factually,
commencement
practically-
of, commencement of trial, my lord, virtually after when the recording of evidence has started, then it's
by framing of the issues itself, the trial commences. Let's see the order of the court, page number
my lord, page number 31, my lord.
31. Yes.
My lord, para number 9, it will start.
Hmm.
During the pendency of this suit, plaintiff died. Thereafter, this applicant and other children of original plaintiff came on record as legal representatives. In the plaint or document produced by the plaintiff, there are no recitals regarding alleged gift deed. The plaintiff produced will dated 1/1/1997. In that also, Asma B has not stated anything about the alleged gift deed. The advocate for plaintiff contended that in the Mohammedan law, there is no necessity to register the gift deed and also not necessary to prepare the gift deed in the writing. It is well settled law that gift may be in the oral or in the Mohammedan law. The defendants also not disputing about the oral gift existed in the Mohammedan law. Hence, the question is whether the plaintiff placed any document to show the alleged gift deed. If the petitioner's mother acquired the right over the said suit property under the gift, there should be some supporting document to show the gift deed. And perusal of record, it is noticed that there is no whisper about the gift. The application should not plead new facts which are not in the knowledge of original plaintiff in the general. If there is any title deed, then definitely the plaintiff should narrate the same in the plaint. As stated above, original plaintiff has not stated anything about the gift deed. There are no supporting documents to believe the existence of the alleged gift deed. Hence, the plaintiff has not made out grounds to allow the IA. Accordingly, answer point number 1. Whether the gift is oral gift is a hiba, it cannot be registered and there will be no document. Only the oral evidence needs to be, through oral evidence, we needs to prove the gift. So the trial.
It is not your case in the plaint that the gift deed is executed and you have been put in possession of the property. That would be the whole basis for your, that would be the main pleading, that should have been the main pleading.
Yes, sir.
How can it be by way of an amendment?
Well, it was left out in the pleading. That is the contention taken by the plaintiff. My lord, it is an opportunity to the plaintiff. My lord, no right will be prejudiced to the respondent. It's an opportunity to the plaintiff to prove the hiba.
By way of an amendment, you can't bring those kind of facts. You can't, why you have not pleaded it? What was the reason for that?
The reason is.
It is not something, no, how can you forget it? That's the whole basis. By way of a oral gift, she has given and put you in possession of the property, and now you are seeking injunction.
So due to lack of knowledge, my lord, instructions were not given at the time of drafting of the plaint.
Please come. Agreed with the orders passed in. Which is the IA?
Sir, IA number is.
Agreed with the orders passed on an IA under order 7, order 6 rule 17 CPC. Invoice number 45 of 2014, dated 14th of June 2019. The plaintiff is before this court. The plaintiff had filed the suit seeking the relief of permanent injunction. It is a case of the plaintiff that the suit scheduled property originally belongs to one Assembly, and the purchase and as who has purchased a property from a lawful vendor through registered sale deed dated 1/1/1991. And after the said purchase of the property, she became she is in lawful possession and enjoyment of the property. And in all the municipal khatas, her name is reflected in all the municipal records. It is stated that the Asma V is the mother of the plaintiff and she executed a registered will in favor of the plaintiff with regard to suit properties on 1/1/1997. And the mother of the plaintiff died on 13/12/2000. Now, by way of this amendment, the plaintiff wants to add
Page
That-
number 22.
Annexure D.
that the property is gifted by his mother orally and delivered the possession of the property in favor of the plaintiff. When that application is filed seeking amendment that came to be dismissed by the trial court by way of the impugned order, the trial court, while dismissing the application, observes that on perusal of the record, there is no whisper about the gift. The applicant cannot pick the new facts which are not in the knowledge of the original plaintiff. No, the original plaintiff and no, the LRs are brought on record.
LRs are brought on record.
This application is filed by the LRs of the original plaintiff. In general, if there is any title deed, then definitely the plaintiff should narrate the same in his plaint. And the original plaintiff has not stated anything about the gift deed. There are no supporting documents to believe the existence of the alleged gift deed. Accordingly, application is dismissed. Learned counsel appearing for the petitioner submits that while entertaining an application under Order 6 Rule 17, court cannot go into the merits of the matter. It is stated that under the Mohammedan law, the gift may be in the oral, maybe a oral gift, and there need not be a document to witness the same. The court, and he submits that only the issues were framed. And now, if the amendment is allowed, no prejudice would be caused to the defendant. The court, without considering the injustice that is to be caused to the plaintiff, has dismissed the petition. Next, learned counsel appearing for the respondent plaintiff, defendant submits that the plaintiff cannot take, by way of an amendment, cannot introduce altogether a new case. He submits that when the original plaintiff had not stated anything about a gift deed, and the original plaintiff is relying on a will, and now the inconsistent stand, the LRs wants to introduce by way of an amendment, which is not permissible. It is submitted that the court had rightly considered the application and dismissed the same. Next para. Having heard the counsels on either side, peruse the material on record. When it is a consistent case of the original plaintiff that his mother has executed a will in his favor and he is in possession of the property and he sought for injunction against the defendants. Now, by way of an amendment, he wants to amend the pleadings by saying that the property was orally gifted by the mother and possession was delivered to him. Which is clearly an inconsistent stand. And by way of this amendment is introducing a new case. Already the issues are framed. Now when an application is filed under Order 6 Rule 17, the party has to say why these things, that in spite of due diligence, they could not bring all these facts to the notice of the court. It is stated that they are not properly able to advise the advocate, the original plaintiff who has filed the suit is aware of the facts and he has, has stated so. Now the LRs cannot introduce a new case. Even on that count also, the writ petition needs to be dismissed accordingly. The writ petition is dismissed.
Just kind leave, but serial number 27, interim order needs to be extended. I'm sorry for that.
27, look at it, interim order, if it is there.
Please,
extend.
please.
Yeah.
Oblige you.
To come, no, it will be convenient for him. Ask him to do it. You can-
Seven ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್ ವಿದ್ಯಾಗೆ
27.
interim order extension.
Sir, ಒಂದು ನಿಮಿಷ 27 ಅಲ್ಲಿ ಐವ ವಿದ್ಯೆ ಅಂತ 36 ಅಲ್ಲಿ ಏನ್ ಬೇಕು ಸರ್? ಡಿಸ್ಮಿಸಲ್ ನಾಳೆನೆ ಆಗ್ತಿತ್ತು ಸರ್. ಹೌದು, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಡಿಸ್ಮಿಸಲ್ ಟುಮಾರೋ. 37 ಪಾಸ್ ಓವರ್. ಮಧ್ಯಾಹ್ನ ಕರೀತೀನಿ 2:30 ಬನ್ನಿ. ಎಸ್ ಸರ್. ಬಿಕಾಸ್ ಅಲ್ಲಿ 36 ಅಲ್ಲಿ ಮಾರ್ನಿಂಗ್ ಯಾರೋ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು 37 ಅಲ್ಲಿ ಅದರ್ ಸೈಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ ಅಂತ ಮೇಡಮ್ ನಾವು ಗಿವನ್ ಸಿನ್ಸ್ ಇಟ್ ಇಸ್ ಪಾಸ್ ಓವರ್. ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಸೀರಿಯಲ್ 27 ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದಿದೆ ಸರ್? ಚೇಂಬರ್ ಅಲ್ಲಿ ಒಂದು ಮ್ಯಾಟರ್ 2 ಗಂಟೆಗೆ ಫೋನ್ ಬಂದಾದ್ಮೇಲೆ ಇಲ್ಲಿ ಪಾಸ್ ಆಗುತ್ತೆ.
ಹೋಗ್ಬಿಡಿ ಮಾಡ್ಸೋಣ.
ಅದು ಅವ್ರಿಗೆ ಏನು ಹಿಂದೆ ಇಡಕ್ಕಾಗಲ್ಲ, ಹಿಂದೆ ಇರ್ತೀನಿ. So, you have to start sheet in the mail.
ಯಾವುದು?
ಡೇಟ್ ಕೊಟ್ಟೆ ಇದೆಲ್ಲ ಹುಡುಗೆ
Madam Court Officer. Court Officer, Madam.
ಏನ್ ಹೇಳಿ ಸರ್?
Madam, serial number 33 ಏನು ಅಡ್ಜನ್ ಆಯ್ತಾ ಏನಾಯ್ತು ಮೇಡಮ್?
ನಾಳೆಗಿದೆ ಸರ್.
ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಅನ್ನೋದು
ಏನ್ ಮೇಡಮ್?
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಟುಮಾರೋ ಅಂತ ಇದೆ ಸರ್ ಅದು.
ಓಕೆ ಡಿಸ್ಮಿಸಲ್ ಗಾ
ಹೌದು, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ನಮ್ ಕೋರ್ಟಲ್ ಅದೇನೆ, ಅಡ್ವೊಕೇಟ್ಸ್ ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಇಟ್
ಹಾ.
ಇಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್.
ಸರಿ ಮೇಡಮ್, ಅದು ನಂಗೆ ವಿಡಿಯೋ ನನಗೆ ಇದಾಗ್ಲಿಲ್ಲ, ನಂಗೆ VC ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗೋಣ ಅಂತ ಹೋದೆ, ಕನೆಕ್ಟ್ ಆಗ್ಲಿಲ್ಲ.
ನಾಳೆ ಬನ್ನಿ ಸರ್, ನಾಳೆ ಬನ್ನಿ, ಇಲ್ಲ ಅಂದ್ರೆ DNP ಆಗತ್ತದು.
ರೈಟ್ ಮೇಡಮ್, ಪ್ಲೀಸ್ ಡೆಫಿನೆಟ್ಲಿ.
ಓಕೆ ಸರ್,
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಕರಿತೀನಿ. ಏನ್ ಸರ್? ಪಾಸ್ ಓವರ್ 2 ಇದೆ ಸರ್. ಎಷ್ಟು ನಿಮ್ದು ಸೀರಿಯಲ್? ಹಾ? ಏನೋ ಡಲ್ ಆಗಿದೆ ಅಲ್ಲ ಲೈಟ್ಸ್.
ಫಸ್ಟ್ ಡೇ ಇಂದಾನೆ ಅನಿಸ್ತಿದೆ ಅಂತ ಡಲ್ ಆಗಿದೆ ಅಂತ.
ಲೈಟ್ ಹಾಕ್ತಿಲ್ವೇನೋ ಅಂತ
ಬರ್ಬಿಡ್ಲಾ ಡೇಟ್ ಅಂತ.
ಯಾವ್ದು
ಡೇಟ್ ಇದೆ. ಡೇಟ್ ಯಾರು ಆಡಿದ್ದಾರೆ ಕಳಿಸ್ತೀನಿ ಅಂದ್ರಂತೆ.
ಆರ್ಡರ್ ಶೀಟ್ ಸೈನ್ ಆಗಿದೆ, ಕಳಿಸ್ತಾರೆ ಒಂದು ನಿಮಿಷ. ಫೈಲ್ಸ್ ಇಲ್ಲೇ ಇದೆಯಂತ. ಫೈಲ್ಸ್ ಇಲ್ಲೇ ಇದೆಯಾ ನಾಳೆಗೆ? ಹೌದಾ? ಅಲೋ ಸುವರ್ಣ, ನಾಳೆ ಡೇಟ್ ಫೈಲ್ಸ್ ಇಲ್ಲೇ ಇದೆಯಪ್ಪ. ಅದ್ರದ್ದು ಆರ್ಡರ್ ಶೀಟ್ ಸೈನ್ ಮಾಡಿಸ್ತೀನಿ ನೋಡಿ, ನಿಮ್ಗೆ ಕೊಟ್ನಲ್ಲ. ಅದ್ರೊಳಗಡೆ ಇವತ್ತೊಂದು ಬಿಂದಿ ಆಗ್ತಾ ಇದೆ ನೋಡಿ, ಸೈನ್ ಆಗಿದ್ದು ತಗೊಂಡ್ಬಂದ್ರ? ಸರಿ ಸರಿ ಆಯ್ತು. ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೌದು ತಾಳಲಿಲ್ಲ ಇದನ್ನ ನಾನು ಬರೀ ಬರೋದು. ಬೇರೆದೆಲ್ಲ ಕಲಿಸ್ತಾರಲ್ವಾ? ಇನ್ನೂ ಇದೆ ಅಂತ ಇದು ನಾಳೆಗೆ ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲಪ್ಪ. ಬ್ಯಾಲೆನ್ಸ್ ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇರೋದು ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡ್ಕೊಳಪ್ಪ. ಡಿಸ್ಮಿಸಲ್ ಅಲ್ಲಿ ಈಗ ಡಿಸ್ಮಿಸಲ್ ಅದ್ ನೋಡ್ಕೊಂಡು ಮಾಡೋ. ಆಮೇಲೆ ಲಿಸ್ಟ್ ಮಾಡ್ತಿರಲ್ಲ ಅದ್ರೊಳಗಡೆ ನೋಡ್ಕೊಡು. ಅಂದ್ರೆ ಈಗ 50-55 ಮ್ಯಾಟ್ರ್ ಒಳಗಡೆ ಈಗ ನಾಳೆಗೂ 15 ಸಾಕು. ಯಾಕೆಂದ್ರೆ ರೆಫರೆನ್ಸ್ ಇದೆಲ್ಲ ಮಾಡ್ಕೊಂಡೆ ಆಯ್ತಾ? ಇಲ್ಲ ಅಲ್ಲ ಅದು ಸ್ವಲ್ಪ ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇರೋದು ನಿಯರ್ಲಿ 130 ಇರ್ಲಿ. ಯಾಕಂದ್ರೆ ನೀವು ಆರ್ಡರ್ಸ್ ಜಾಸ್ತಿ ಆದಾಗ ಬಿ ಗ್ರೂಪ್ ಲೆಸ್ ಮಾಡ್ಬಿಡ್ತೀರಾ ಮೇಡಮ್. ಅದು ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬೇಗ ಇದೆ. ಅದಕ್ಕೇನೆ ಡಿಸ್ಮಿಸಲ್ ಕ್ಯಾಪ್ಷನ್ ಇದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಬಿ ಗ್ರೂಪ್ ಅಂತ ಹಾಕಿ. ಡಿಸ್ಮಿಸಲ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ರೆಡಿ ಇದ್ದಾನೆ ಅಂತ. ಅದಲ್ಲ ಅದು ಅಡ್ವೊಕೇಟ್ ರೆಡಿ ಇದ್ದಾನೆ ಅಂತ ಮೇಡಮ್ ಕ್ಲಿಯರ್ ಮಾಡ್ಕೊಡ್ತಾರೆ. ಈವನ್ ಇಫ್ ಇಟ್ ಈಸ್ ಇನ್ ಡಿಸ್ಮಿಸಲ್ ಆಲ್ಸೋ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಬಿ ಗ್ರೂಪ್ ಅಂತಿದ್ರೆ ಮೇಡಮ್ ಗೊತ್ತಾಗುತ್ತಲ್ವಾ? So ಅವಾಗ ಅದು ಇದು argument ready ಇದ್ರೆ ಹೋಗ್ಬಿಡ್ತಾರೆ ಅಂತ. Otherwise bracket B group ಹಾಕಿ ಅದು plus ನೋಡ್ಕೊಂಡು ಅದನ್ನ ಡೇಟ್ ಇದು ಎಲ್ಲ ಸೇರಿ ಅದಕ್ಕೆ ಏನಾದ್ರು ಸ್ವಲ್ಪ ಆರ್ಡರ್ಸ್ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಅದನ್ನೇ ಹೇಳ್ತಾರೆ ಡೇಟ್ ಇವನು ಸೇರಿ ಅದನ್ನ ಫೈಲ್ ಅವಾಗ ಬೇಕು ಅವತ್ತು ಬೇಕಾದ್ರೆ ಪ್ರಾಸೆಸ್ ಇರೋದು ಜಾಸ್ತಿ ಕ್ಲಿಯರ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ. ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರು ನೋಡಿ 2017, 18, 19 ಅವೆಲ್ಲ ಫುಲ್ ಕ್ರೋನಲ್ ಆಗಿ ಇನ್ನೂ ಇದೆಯಾ ಯಾರಿಗೆ ಇವಾಗ ತಗೊಂಡೋದಿಯಲ್ಲ ಆ ಫೈಲಲ್ಲಿ ಇಲ್ವಪ್ಪ?
ದೇವರಾಜು ಇನ್ನೊಂದು ಬಂಡ್ಲು ಇದು ಟ್ರಾಲಿಯಿಂದ ತಂದ್ರು ಎಲಿಟ್ರು ಅದರಲ್ಲಿ ಸಿಕ್ಕಿಲ್ಲ.
ಏ ನೋಡಪ್ಪ ಆರ್ಡರ್ ಶೀಟ್ ಎಷ್ಟು ಸಿಕ್ಕಿಲ್ಲ? ಒಂದ ಎರಡ ಡೇಟ್ ಇವನೇನಾ? ಇವ್ರಿಗೇನಾದ್ರು ತಗೊಂಡೋಗಿ ಇಟ್ಬಿಟ್ಟ ನೋಡು ಆರ್ಡಿಗೆ. ಅಥವಾ ಡಿಸ್ಪೋಸಲ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಮೆಮೊ ಫೈಲ್ ಕೆಪ್ಟಿಲೋನಲ್ಲೂ ಇದೆ ಅನ್ಸುತ್ತೆ ನೋಡು. ಫೈಲ್ ಸಿಗ್ಲಿಲ್ಲ.
ಫೈಲ್ ಎಲ್ಲ ಅವ್ರ ಜೊತೆ ಅಲ್ಲಿ
ಡಿಸ್ಪೋಸಲ್ ಜೊತೆ ಮಿಕ್ಸ್ ಮಾಡ್ಬಿಟ್ರೆ
ಇಲ್ಲೇನು ಇಲ್ಲ ತಾನೇ ನಮ್ಗೆ ಬೇರೆ ಫೈಲ್ ಏನು
ಅಷ್ಟೇ. ಪಾಸ್ ಆಗೋದು ಎಲ್ಲಾ ಫೈಲ್ಸ್ ಹೋಗಿದೆ ಸರ್. ಪಾಸ್ ಆಗೋದು ಡಿಸ್ಪ್ಲೇ ಬರ್ತಾ ಇಲ್ವಾ ಸರ್? ಬರುತ್ತೆ.
ಏನಾಯ್ತಪ್ಪ ಈಗ
ಹೊರಟಾಯ್ತಾ? ಅಲ್ಲಿ ಏನೋ ಆಗ್ತಿದೆ. ಅದು ಬೆಳಗ್ಗೆ ಹಂಗೆ ಆಗ್ತಿದೆ. ಗೊತ್ತಿಲ್ವಾ ಡಿಸ್ಪ್ಲೇ?
ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಇವತ್ತು ಪೂರ್ತಿ ದಿನಾನೇ ಪ್ರಾಬ್ಲಮ್ ಕೊಟ್ಬಿಡ್ತೀವಿ.
ಅದೇ ಇವ್ರೇನು ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಬೆಳಗ್ಗೆನೆ ಹೇಳಿದೆ.
ಬೆಳಗ್ಗೆ ಎಷ್ಟು ತೊಂದರೆ
ಬೆಳಗ್ಗೆ ಒಂದು ನಿಮ್ದು ನಾಳೆ ಹಲೋ ಇದು ಇಂಪಾರ್ಟೆಂಟ್ 20 ಡಿಸ್ಪ್ಲೇ ಪ್ರಾಬ್ಲಮ್.
ಸಪರೇಟ್ ಆಗಿ ಬರಲ್ಲ.
ಹೌದಿತ್ತು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ರು ಅದು ಡಿಸ್ಪ್ಲೇ ಬರ್ತಾ ಇಲ್ಲ. ಬಂದಿತ್ತು ಬೆಳಗ್ಗೆ ಕರೀತಿದ್ರೆ ಮತ್ತೆ ಇವಾಗ ಡಿಸ್ಪ್ಲೇ ಹೋಗ್ತಿದ್ದಾರಲ್ವಾ? ಯಾಕೆಂದ್ರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಗೊತ್ತಾಗದೇ ಇಲ್ಲ. ಮತ್ತೆ ಪದೇ ಪದೇ ಬಂದು ನಿಮ್ಗೆ
ಮೂರು 37 ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ
ಏನಾ? 3:37
ಇದೇನಾಯ್ತು ಮೇಡಮ್?
ಏನೋ ಚೇಂಬರ್ದು ಡೇಟ್ ಹೋಯ್ತು. ದಟ್ ಈಸ್ ಆನ್ 4/2
ಹಿಂಗೆ ಆಗಿಲ್ಲ.
ಹಲೋ 41 13 ಹೋಗಿದೆ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಮಂಡೇ. ಸೇಮ್ ಆಶ್ಚರ್ಯಕ ಅದೇ ಅವ್ರ ಪೆಟಿಷನರ್ ಅಡ್ವೊಕೇಟ್ ಕೇಳಿದ್ದಾರೆ.
ಮಂಡೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದೇ ಹಾಗಾಗ್ತಾ ಇಲ್ಲ.
ಅದೇನಾಗಿದೆ?
ಅದೇ ಹಾಗಾಗ್ತಾ ಇಲ್ಲ. ಏನಾಗಿದ್ಯೋ ಅದನ್ನೇ ಅಲ್ಲೇ ಹೊರ್ಟಾಯ್ತು ನೋಡು ಡಿಸ್ಪ್ಲೇ ಬೋರ್ಡ್. ಏನಾಗಿದೆ?
ಯಾರು? ಎಲ್ಲ ಸ್ಲೀಪಿಂಗ್ ಮೋಡಿಗೆ ಹೋಗುತ್ತಾ? ಸ್ಲೀಪಿಂಗ್ ಹೋಗುತ್ತೆ. ನಿಮ್ದು ಮಾಡ್ಕೊಳ್ಳಿಪ್ಪ, ನಾವು ಅವಾಗಲೇ ಮಾಡಿದ್ವಿ ಅದೇನೋ.
We filed an appeal. In the appeal, my lord, the first of the court found fault in the approach of the trial court, saying that the entire judgment is based on some revenue orders passed by revenue officers. You must reconsider it. You are a civil court. You must adjudicate the rights of the party. You can't rely upon some order of the revenue court and then pass orders affecting the rights of the party. Remand is the matter. Well, remanding, my lord, the usual terms are the parties are free to re-educate, my lord, amend, take up new contention, the standard order.
Where is that order?
Yes, please stay, my lord, the appellate court order. The lords will kindly get, lord, the operative portion. These things, my lords will kindly take. But the questions that are raised, issues concerns, all at page number 78 onwards. 78, my lord.
These findings, remand.
Findings, my lords, kindly take, my lord, page number 86, para 21.
No, remand with regard to all these issues, what to be decided.
Page number, lord, 104, 102, 102.
What is the traditional issue?
Traditional issue, my lord, in relation to, my lord, maintainability of the suit. Jurisdiction, because, my lord, a pleading is taken in the written statement that these properties were dedicated to a trust. And since it is a public trust, section 92 will apply.
But suit is not maintainable.
Therefore, suit is not maintainable, the contention is there.
And what is the amendment that he sought?
Same thing, now after remand, my lord, he wants to, my lord, again re-agitate the very same rejected amendment application on the case that liberty has been given to me by the first of the court. Lord, liberty is given.
That very same amendment.
Just not manipulated the words of it, but very same application is filed again. No reasons are given. The reason is, please look at the first of the court has said, I am entitled to comment.
Please come to the impugned order.
Yes, take first take. The order that was rejected earlier. So that my lords will get, that page number 40, A number 22 is rejected. Page number 42. Lord, the trial court considers the mark under the
In the affidavit, let us read from page 40. In the affidavit annexed to the application, the second defendant has stated that 40, the first para itself.
Yes, sir. The affidavit annexed to the application, second defendant stated that since the matter involved in the suit in respect of trust property, proposed amendment with regard to maintainability of the suit is necessary to determine the real question in part of the legal party. Therefore, sought for the proposed amendment in the written statement. Plaintiffs have filed objections to IA 22. We contended though the proposed amendment, the defendants are raising the point of view, claim cannot be allowed as per provisions of section 21. At this belated stage, plaintiffs are further contended.
Now, the additional issue that is framed is with regard to the maintainability of the suit. Why can't this be taken when the issue itself is there?
In protracting the proceedings, please see the written statement. It is already there.
Where is it?
But please turn to page number 26. Page number 26, para 9. Para 9, my lord, at the end of the page 26. This contention is already raised, which is why an issue is present. There is no pleading.
No, your suit of 2019, for that reason, you are here till 2024, 5. Now, what is the prejudice that is caused to you if that is done?
It is only dilatory
It
tactic.
is not, it is no new pleading is taken. No, dilatory is appears to be from your side, keeping the suit pending from 19 to your own suit till 2025.
If amendment is allowed, additional issue, then again I will have to get into.
Additional issue is already there.
Additional issue is already there, but no necessary evidence. But what the High Court says, based on revenue audits, I will. The case is decided.
Maintainability of the suit,
Yes,
an additional issue is framed
No,
by,
it was already there. I show the issues to my lords, but we see the trial court.
no, you have not questioned that order of the law, the appellate court where it gave liberty to amend the pleadings. No, that your contention with regard to the pleadings at a belated stage will not arise now.
Same amendment application is rejected and my lord, the matter is remanded back. Will it amount to a fresh institution of the suit? It is nothing but a continuation of the suit. But what is rejected cannot now again be allowed. But we see the my lord, the issues. But please turn to page number 52. It is not that it was not there. What is trial court?
No, only thing is, according to you, it is all protracting the proceedings, dilatory tactics. Now, what has happened now?
Once the application is rejected, Lord, we cannot file the very same application again.
What is the consequence of that application?
Consequence is not what is already decided, but then there is no value for court orders.
No, what court order?
Court order is rejected. I don't think it is rejected. By saying, my lord, it is not.
Then why you have not questioned another court order? Then that also has no value.
The observation was not in relation to IA 22.
Who should tell that?
Before the appellate court saying that I had raised this objection, I had raised this in the written statement, I had raised it in the amendment. Amendment application is not allowed. That is wrong. And if the first appellate court was said, yes, approach of the civil court is wrong. Therefore, I give you liberty. Not yes, my lord, I have no voice. But if that is not the contention, and the first appellate court would only say that please look at, that's why, my lord, please have a look at page 52. The issue relating to jurisdiction is there already. It was not a new issue that was framed by the first appellate court. Please see page number 52. Whether the defendants prove that this court has no subjective jurisdiction to entertain this issue, page number 52.
Yes. Yes.
Now, Lord, if my Lord sees the order, my Lord, this order having again finality at page number, my Lord, 40.
Yes.
So question of my Lord, again, the very same court, my Lord, saying I will allow the application does not arise at all.
Yes.
Lord, please see, Lord, page number 43.
Yes. Yes, I'm at 43.
43, yes, point number 2 and 3. Therefore, my Lord, first question, my Lord, at page number 42, my Lord, due diligence is not pointed out. Page number 42, in the above express bar, to amend the pleadings after the commencement of trial, amendment can be permitted only if the party is able to show. In spite of due diligence, he could not have raised the issue before the commencement of trial. But in the present case, since issues have already been framed on 26/7/2012, the trial court has commenced, the trial has been to be commenced from that date itself. Present application is filed after 4 years, after completion a substantial portion of evidence, without assigning any reasons. In the affidavit annexed to the application, there is absolutely no reason to fulfill the requirements of proviso to order 6 rule 17, hence I answer it in the negative. So therefore, on the proviso aspect, my lord, it is rejected. Now coming to, my lord, the substantive portion of what they want to say. They would say, my lord, this is a question of law. Please see, my lord, point number 2 and 3.
Yes.
Lord, I will just read about, my lord, 10 lines from para 7.
Yes.
They have further contended that no trustee is also. Therefore, the question being question of law. While determining the disputed issue, giving finding it is necessary to ascertain whether this court has jurisdiction to decide the suit or not. Learned counsel appearing for the plaintiff has contended that as per section 21, question of jurisdiction cannot be raised at the later point, and it shall be raised only with regard to territorial pecuniary jurisdiction or not subject to jurisdiction. In the present case, question raised by the defendant is subjective jurisdiction. Therefore, the question of subjective jurisdiction can be raised at any stage. Any judgment rendered by the court without subjective jurisdiction is non-est in the days of law.
Yes.
For that reason, proposed amendment is not necessary. What they would say is whether it is section 92 is a law or not, is the question of law, you treat it. And therefore, issue came to be fair, which I wrote your lordship. Now, please see the second amendment application. Very same thing is, my lord, again mentioned. Please take the affidavit. Page number 105.
Yes.
Nothing is mentioned about due diligence. Nothing is mentioned about the issue which is already framed before the trial court. Nothing is mentioned as to why this additional paragraph is necessary. Please see, my lord. Page number 105. The fact about this clause should have been treated in our written statement, but unfortunately, the same could not be treated due to bona fide mistake. It is factually incorrect. I have shown to my lords, it is already there. So therefore, no prejudice is going to be passed because the issue is already framed. After coming to know the mistake, we filed IA 22 for amendment, but the same is rejected. However, the appellate court has permitted to amend our written statement. Same we have filed is applicable. Only one line.
Yes.
So therefore, my lords, the submission would be but the adjudicator would apply a lot to the within the same proceedings. It need not be a lot of separate proceeding.
Take that. Yes.
We take Lord, after considering all the judgments, Lord, whether there can be adjudicator within the same proceeding. Please see, my lord, para 10, at page number 13, page number comes at the bottom of the bottom. Page number 30.
Yes.
My lord, para 10. From what has been noticed and discussed, my lord, earlier paragraphs and because, my lord, all the various, my lord, judgments are occurred. It remains hardly a matter of doubt that the doctrine of adjudicator is fundamental to every well-regulated system of use students from being founded on the consideration of public policy. That a judicial decision must be accepted as correct and no person should be vexed twice with the same kind of litigation. The doctrine of adjudicator is attracted not only in separate subsequent proceedings, but at the subsequent stage of the same proceeding. Moreover, a binding decision cannot be directly ignored. Even an erroneous decision remains binding on the parties, the same litigation and concerning the same issue if rendered by a court of competent jurisdiction. Such a binding principle cannot be ignored, even on the principle of per incuriam, because the principle applies to precedents and not the doctrine of adjudicator. Then, here also two applications were filed. First application got rejected. Same application was filed subsequently. Now, coming to the statutory bar, under the proviso, there are many judgments. I'm just placing blank only on one judgment.
Yes.
Please take para 11 and 12, my lord. After noticing the word judgment, para 15, my lord, 1-5.
Yes.
Sorry, my lord. Para 10, my lord, the amendment is noticed. Page number 413, para 10, my lord, para 11. From the order passed by the learned trial judge, it is evident that the respondent has been able to, not been able to fulfill the precondition. The question, therefore, which arises for consideration is whether trial court had commenced, the trial had commenced or not. In our opinion, it did. The date on which issues are framed is the date of first hearing. The provisions of this new procedure code envisages taking of various steps at different stages of proceedings. Filing of an affidavit in lieu of examination in field with the witness in our opinion would amount to commencement of proceedings. Then, my lord, they would notice other judgments. Then order 18 to 14 is noticed. Then, my lords, we kindly subprove the lord para 15.
Yes.
By Act 46, my lord, they extract the proviso. Then, my lord, para 36 is, my lord, extracted. At para 50, continuated to strike a balance, the legislature applied its mind and reintroduced Rule 17 Act 24/2002. It had a provision permitting amendment in the first part.
which said that the court may at any stage permit amendment as described here, but it also had total bar by a proviso prevented any application from amendment to be allowed after trial had commenced, unless the court came to the conclusion that in spite of due diligence, party could not have raised the matter before the commencement of trial. It is that proviso that calls for consideration.
Yes.
Then, my lord, please come to para 19. Both the applicant as well as the court must be satisfied, and the finding must be shown that due diligence was exercised, otherwise it can't be allowed. Para 19. It is the primary duty of the court to decide as to whether such an amendment is necessary to decide the air dispute between the parties. Only if such a condition is fulfilled, amendment is to be allowed. However, proviso appointed to Article 6-17 of the court restricts the power of the court. It puts an embargo on the exercise of its jurisdiction. Court's jurisdiction in a case of this nature is limited. Thus, unless the jurisdiction of fact as envisaged therein is found to be existing, court will have no jurisdiction at all to allow the amendment to be made. So therefore, my lord, my respectful submission is, it must come to the conclusion that, my lord, there was sufficient cause made out due diligence law. Therefore, my lord, that is not there. Affidavit does not disclose it. Therefore, my lord, my submission is, the amendment is not necessary. Please have a look at what they want to say in the amendment, my lord. Let's go that to my lord. Page number 104, page 23.
Yes.
Para 1080, the honorable court has no jurisdiction, that is subject to jurisdiction to decide the matter in dispute in the case. Since the trust is created in respect of the subject matter of the food property, the provisions of section 92 is to be followed. Whereas the plaintiffs have not followed the said mandatory provision of law, hence the above food is not maintainable and is liable to be dismissed. But already issue is there because there's a pleading in the written statement. Now, my lord, what the trial court says is, if there's any aspect to be gone into, if any evidence is there, you please read it. But there is no, my lord, point in, my lord, introducing something which is already there and issue which is already framed. Therefore, my lord, in the respective submission, but the order also does not, my lord, speak of any due diligence. All that it says is, my lord, the appellate court has allowed it, therefore, appellate court never had a opportunity to consider this. Why the matter is remanded, my lords will get at, my lord, page number 86. Where they say, my lord, the trial court judgment is only based on, my lord, the order of the assistant commissioner. And, my lord, that order of the revenue officer cannot, my lord, be binding on a civil court. Civil court has to independently adjudicate it. So therefore, my lord, that liberty which is given cannot be, my lord, read into, my lord, by saying that what is already dismissed, accepted by the parties, my lord, is given a fresh piece of life. And, my lord, that would be, my lord, doing violence to section 11.
Yes.
In appeal, both the appeal are allowed to first appeal for page number 103. It is specifically observed. Acting under 41.23A, above page behind the trial.
I've seen this.
And the trial court is specifically observed liberty to the defendant and as well as the plaintiff to amend the pleadings in case it is necessary. As per that, I make a necessary application could be allowed. Based on that, against which they have prepared an appeal. And the very maintainability of the suit itself is challenged, contested by the defendant. And that has to be brought to the knowledge of the court by way of amendment. The amendment has not, that has been clearly allowed, and it has been typically mentioned that there is no bar, because there is a different case given by the.
No, that is one aspect. That is one aspect. Now, already there is, your case is that the suit is not maintainable. And the court has also framed an issue with regard to that. What is the purpose of this? There are no other facts which you are bringing to the notice of the court. And if the same are not brought to the notice, what is the prejudice to cause to you? If that line is not, what line you want to incorporate by way of this amendment is a issue that is precisely framed. Just forget about it. Now, if a prejudice is going to be caused to you, irrespective of what the plaintiff says, if the prejudice is going to be caused to you, in the light of that liberty given for the amendment, you can ask for amendment, whether it is right or not, court will look into it. But now, your case is that the suit is not maintainable because it is a public trust. That's the only line you want to insert by way of an amendment. Exactly, that is what the court had taken. And you have taken in your pleadings in the written statement that it is a public trust. No, it is not, we are not on a preliminary issue. We are on an amendment of pleadings. In the light of an issue being already framed, now both of you are playing with the plaintiff as well as the defendant. You think that, on one pretext or the other, why you want a additional, this amendment, court is not able to understand. Even if it is, if he wants to pursue his matter, why is he before this court? That also court is not able to understand. I think by imposing costs on both plaintiff and defendant, this has to be dismissed.
Page 90, where the additional issue arises in relation to limitation and non-judgment of part. In that regard, if you want to lead any evidence, you want to amend it, you please amend it, is what the please see page 90.
No, even otherwise also, it's a frivolous litigation. What the plaintiff is, prosecuting. No, your suit, if really you have any bona fides, there is no prejudice to you. Already an issue is there. If that amendment is allowed, how it causes prejudice to you?
But evidence will have to be read. But that is why
What evidence?
But because there is
It is just a sentence. Just a sentence.
there is no evidence. But that will
No. I'm saying, let's forget about what they will do. One sentence, what they do, they're not saying, putting forth any other new facts. They are not putting forth any other issues or any other evidence to be let in. It is an issue more on a question of law. And you also accept that it is a public trust. In that case, and then if it is not, then the burden lies on you.
Insertion of one line, they will claim a right to lead evidence to law. They will claim a right to lead evidence because pleadings are
Nothing but wasting the court's time. Suit is of which year? Suit of 2010. We are in 2025.
Liberty is not.
No. What I'll do is, I'll allow your writ petition with costs on you.
My only request is
Not it is,
please allow it to show my bona fides.
no, I'll impose costs on them, on you also.
Once not, please give a direction, we will cooperate.
No, that will be done. That will anyhow be done now, but it would be with costs. It would be with costs on both of you. What is this? It's a frivolous litigation that the plaintiff is fighting for no prejudice either to him or to you. Why he wants it? No reason. Why you do not want it? No reason. But just because an order is there in favor of a defendant, plaintiff should question it before the appellate court. It's a simple rule. No, you wanted because they will adduce an additional evidence. You come before this court, and you are waiting from when? Which year is there? You are waiting from last 5 years here. It is now. No, it's high time. It's a. No, it should be in the interest of how the interest of the party is affected. Not just like that one order is in favor of defendant, so plaintiff should come. There is an order in favor of plaintiff, so defendant should come to the court. That should not be. And that sort of a litigation shouldn't be entertained by the court and encouraged. In this case, once the matter is remanded, it should have gone as it is. Anyhow, he has filed a petition. Court has allowed it. Now, if you proceed with the matter, no prejudice to you at all on the face of it. And only one reason you say is, unnecessarily they will lead evidence. Even if they lead evidence also, by this time, the suit would have been concluded long back. And ultimately what the conclusion court understand or court has to draw is, you don't want a logical conclusion to your litigation. Let me see why 2019 is pending.
7/1/2020. We wanted to drag it, my lord, we would have, my lord, asked for time immediately, my lord. That's why I said, now that, my lord, a separate, my lord, roster is given to my lord. Of all old matters, my lord, it will reach, otherwise, earlier, my lord, all the years, my lord, was given.
No, but as you know, there's a very sorry state of affairs. It's a sorry state of affairs for this civil litigation is concerned. Like if just a CRP for no reason, no, the provisions of that interlocutory application, the purpose is something else, not this, they're not these kind of, and that too to be pending from 19 to 25, and 25 without, on a stay, without any reason. It is not against the advocates, Mr. Counsel. It's not against the advocates. It is about, from the side of the client, why is he fighting for no reason? Anyway, if he comes, you will file the case. But why is he fighting? What for? Will allow the writ petition.
And I only request.
Don't waste your time on this. No, just because court has given you liberty. Let us take it. Let us take it from what you say. Court has given you liberty. Because somebody has given you liberty without you requiring anything, you will, because there is some facility in the hospital for operation, so you will without any reason get yourself operated. No, isn't it? There is nothing. You're there, you're playing. No, one more thing is, one more thing is, in support of that plea, that the court has no jurisdiction, some other factual aspects need to be brought to the court. And all that you need to incorporate in an amendment, then I can understand. It is not even a case. Just one line you want to say that the suit is not maintainable. And in that regard, already an issue is framed. Please come. Agreed with orders passed in I number 22. Where is that impugned order? The present petition is filed. Agreed with orders passed in I number 23. This is number 18 of 2010, dated 24 June 2019, whereby the trial court had allowed an application filed under Order 6, Rule 17, filed by the defendant. The facts of the case are, the suit is filed by the petitioner herein, who is the plaintiff in the suit, seeking
For declaration. And my lord, consequential relief of injunctive.
seeking declaration that
That he is the absolute owner, plaintiffs are the absolute owner.
that is absolute owner of the suit scheduled property, and consequently a permanent injunction restraining the defendants from interfering with the plaintiff's peaceful possession and enjoyment of the property. In the suit earlier, the defendant had filed IA number 20 earlier, IA number 22, seeking amendment of the written statement, whereby he wanted to add a paragraph that the plaintiff is a public trust and the suit is not meant. Property belongs to a public trust. As such, the suit is not maintainable. That IA came to be dismissed by the court, holding that that is not necessary, that amendment is not necessary to adjudicate the dispute between the parties and at a belated stage. Second one is?
The second one is, it's an issue of law, therefore.
It's a question of issue. It's a question of law, and that an issue came to be framed, and accordingly, issue framed as such has dismissed the IA. Thereafter, that suit itself came to be dismissed. Aggrieved thereby, the plaintiff had filed RA number. You also, both the different, the plaintiff had filed RA number 2 of 2018, in that the defendant had filed a counterclaim.
That claim to be dismissed, so they are.
No, so in the suit, the defendant had filed a counterclaim, and both are dismissed. And when both are dismissed, both of them have carried the matter in appeal. The appellate court had set aside the order passed, has set aside the judgment decree passed by the trial court and remanded the matter for fresh consideration.
Yeah, cross appeal. Only a cross appeal.
So, remove the counterclaim. In the appeal, the defendant has filed a cross appeal. That the court by judgment, that is RA number 2 of 2018, and the court by judgment and decree 3rd of July 2018 had remanded the matter. And court has observed, while remanding the matter, the appellate court has observed that the trial court shall frame additional issue and also afford the opportunity to both the parties to amend their pleadings and to file rejoinder if any, and also to lead the evidence. Concerning the pendency of the case, the trial court was directed to dispose of the matter within 10 months. After the remand, the defendant once again filed an application seeking amendment of the written statement. On the maintainability of the suit under in view of section 91 of the CPC, 92 of the CPC, that came to be dismissed, that came to be allowed by the court by order, by the order impugned. That is at page number?
Page number 111. 24.
The court, while allowing the said application, observes that no doubt the doctrine of res judicata is applicable to interlocutory applications also, but in the peculiar facts of the present case, it is to be noted that the proposed amendment sought for by the defendant is with respect to maintainability of the suit filed by the plaintiff, and it touches the very jurisdiction of this court to entertain the suit of the plaintiff. And such a point of law can be urged even at the time of arguments without supporting pleadings. But the appellate court has clearly reserved the liberty to both sides to get their pleadings amended and file rejoinders if any. Under such circumstances, the application filed by the defendant is not hit by doctrine of res judicata, and the amendment is very much essential for effective disposal of the case, and accordingly allowed the application. Learned counsel appearing for the petitioner submits that when once an application filed by the defendant under Order 6 Rule 17 is dismissed, he cannot re-agitate the very same issue and file another application under the guise of the orders passed by under the guise of the remand order. He submits that the same is part by res judicata. In this regard, he had relied on the judgment of the apex court in case of S. Ramchandra Rao versus S. Nagabhushan Rao and others, reported in 2022 Live Law SC 861. And also he relied on another judgment of the apex court in Vidyabai and others versus Padmalata and another, reported in 2009 to SCC 409. Relying on this judgment, and counsel submits that after commencement of the trial, without even an avowment that that in spite of due diligence, that these particular facts could not be brought to the notice of the court, and the court, without even exercising the jurisdiction, judiciously, had allowed the application. He submits that while passing the order, court ought to have given reasons for allowing the application. It is submitted that court is simply placing an order passed in the RA has allowed the application under Order 6, Rule 17, which is contrary to the settled law. Next paragraph. Counsel appearing for the respondent defendant submits that when the matter is demanded by the court had given liberty to all the parties to file the to amend their pleadings, if any, and to file appropriate applications, and in the guise of the liberty given by the court, the question of res judicata will not arise, as it is in the interest as the property is public trust property. The suit is not maintainable, and as the issue goes to the root of the matter, and which is very much essential for adjudicating the dispute between the parties, the amendment ought to have been allowed by the amendment has been allowed by the court, and there is no illegality with the said order. Next paragraph. Having heard the counsels on either side, produce the material on record. The application under Order 7, Rule 11 was originally dismissed by the court, and the suit was also dismissed. Appellate court had remanded the matter, and the petitioner the defendant has again moved the same application, which came to be allowed only on the ground that the liberty is given by the appellate court. This is a suit of 2010. The case of the defendant, even in the written statement, is the property is a public trust property. The issues were framed in that one issue is framed whether the suit is maintainable in view of Section 92 of the CPC. Additional issue. An additional issue. Whether the court has a subjective jurisdiction to entertain the suit in view of Section 92 of that's not the issue. Only whether the court has the jurisdiction, subjective jurisdiction to entertain. Whether the court has no subjective jurisdiction to entertain the suit. By way of this amendment, again the defendant wants to amend, stating that court has no jurisdiction to entertain the subjective jurisdiction to entertain the suit. Both are one and the same. It's a different way of putting it. Though it is stated that it is not maintainable, the additional issue that is framed and the amendment that is seeking are one and the same, though it is worded in a different manner. When the defendant, when there is an additional issue, there was no reason for the defendant to file a amendment petition. He filed a petition and the court has passed an order. When the court has already passed an order, that is questioned before this court by way of this present writ petition. If such an amendment is even ordered and allowed, no prejudice would be caused to the plaintiff. And the contention of the learned counsel for the petitioner plaintiff is the defendant has been filing these kind of applications to protract the proceedings. The submission of the counsel for the petitioner, this court is not able to understand and appreciate, as this writ petition is filed in the year 2019. Until 2025, the same is pending before this court. Even if with the same written statement, addition, amended written statement, even if the case is proceeded by this time, this case could have been taken to a logical conclusion. It is very unfortunate that in this civil litigation, parties, for the reasons best known to them, are filing the cases just because a remedy lies to the party. All said and done, the fact remains is the court, while allowing an application under Order 6, Rule 17, ought to have looked at the several aspects, particularly the necessity for the amendment, whether the case is made out by the defendant or not. Considering the additional issue already framed, such an amendment is not at all necessary. In that view of the matter, the order impugned is set aside. Number 2, that considering that this is a suit of 2010, the trial court shall proceed with the matter and dispose of the same as expeditiously as possible, but not later than 6 months. Yes.
7. Siddhappa BM.
Superior for the petition.
Yeah. Huh? You are for?
I am appearing for the petitioner.
Why tomorrow? She is seeking adjournment to tomorrow.
Day after tomorrow, please, madam.
Yes, day after tomorrow, at the request of learned counsel for the respondent. Yes, next.
Case number 48.
For the respondent in this case, my lords. My lords.
You are the? It is reversed. Let's go to the trial court order first.
Forty-seven.
Page number? We'll read from, we'll read from page number 52, para number that 9 or 6. Read from there.
The settlement register believes that shipment property was pending in the name of
That is your father.
Yes, his mother. During the year 1965, the handwritten RTC extract given stand 1968 to 2001 suitable properties pending in the name of the computerized RTC reveals that in the year 2017 and 18, said properties pending in the name of Thakur Naika. Not Thakur Naika is the plaintiff hearing, which is Sir, not Nanya Naika. In other words, it reveals that one Nanya Naika, son of Naika, had 2 children, Nanya Naika and Ram. is not the defendant's contention. Said Ramanayaka had 5 children.
So both the plaintiff and the defendants are related.
Relatives, my lords, relatives.
Claiming that not of that Nandya Nayaka is father. But defendants claiming that not of the Nandya Nayaka is their grandfather. But that is why not of the trial for me.
No, let me understand it. According to in whose name the property stands, according to you, he is your father. According
No,
to
my
them-
lords, it is two different persons. My contention is they are two different persons. My grandfather is not his father. Their names are similar. That was a common name.
Certification.
That is a common name which is put. Illa, not taken. I will demonstrate, my lord.
No. Content will understand the case.
Claiming that Nandya Nayaka is not the father of
Plaintiff.
but the defendants claim that Nandya Nayaka is not the grandfather of not of this defendant.
But not your, but the very same person is not your father is their contention.
No, ma'am. Let them
No.
show, ma'am. Let me show, not let them.
I will.
Where is that? Let's see.
My lords, kindly, my lords, I would like to take their very own plate, my lords, in that also and in the this way, Nanya Nayaka,
From the
just my
papers.
lords. Please, my lords.
What have you filed? Where is
Uh,
your written statement?
My lords, I have filed my written statement at page number 42, my lords. Annexure H. Annexure H, and the relevant portions are in Kannada, page number 44, my lords. May I read para number, the second para, my lords? If subject to my friend's correction. In this, my lords, they say, my lords, my grandfather's father name, great grandfather's name is Megya Naika. And who claims his father, Nanya Naika's father is Gemya Naika. So they are two different individuals. And my grandfather got land granted in the year 4/6/1966. And from then, it was coming in my name, in my grandfather's name, Nanya Naika, my lords. And
No, we'll
in
see.
the RTC also,
No.
the Nichapur is the place, my lords.
1 minute.
Please, my lords.
As per the RTC extracts,
Please,
it
my lord.
stands in the name of
Nanya Naika, Nichapura.
1 minute. Nanya Naika, son of
Megya Naika, but that is not shown. Megya Naika is not shown, but according to us, it is
not there in the record.
but there is one, the relevant thing is Nichapura. Nichapura is the place, my lords. Nanya Naika, Nichapura. So, in my WS, I have taken a specific contention.
What is the name of the plaintiff?
Thakra Nayak.
What is your father's name?
My father, Rama Nayak.
Rama?
Rama Nayak.
And you have no brothers and sisters?
Sisters are there, 3 sisters are there.
No brother is there. If the same analogy what you say it has to be taken, then Kakra Naik and Rama Naik shall be the brothers.
No, they are different.
You are disputing that. He is disputing that. We'll go back to that again now, to the order. Again, we'll go. No, you please start reading from where we stopped. At
Page number,
53.
para number 9, my lords.
53.
Ah.
Starting. The genealogical tree reveals that.
Megyanaka had 2 children named Hammanaka and Ramanaka. Said Ramanaka had 12 children. That is dependent. The notice reveals that one Ramanaka has issued notice to ICICI bank manager stating that the loan sanctioned to one L. Nandanaka, son of Hariyanaka, by mortgage into property. Said property belongs to him. Said L. Nandanaka has no right to said property. The copy of the petition reveals that one Hammanaka and Ramanaka preferred appeal against the Naika and 4 others for cancellation of notation bearing number 1. In this regard, on 2011-2018, Assistant Commissioner Arapanvelli has written a letter to the President directing him to conduct the inquiry and district court and submit a report regarding the notation bearing number 1. The application reveals that on 24/11/2015, one Thakra Naika plaintiff has given an application to the President for changing the Thakra name by virtue of both the after death, father's death, also, wherein his father name is mentioned as Nanya Naika, son of Gana Naika. The genealogical tree pertaining to the family of the 20 reveals that one Nanya Naika, son of Gana Naika, had 4 children, namely Kakra Naika, Kamlabai, Geeta Bai, and
Lallibai.
However, the document produced by both the parties discloses that these two children property originally standing in the name of one Hoskoti Karna Lambani Nanya Naika. According to the plaintiff, the said Nanya Naika is his father. According to the defendant, said Nanya Naika is their grandfather. However, whether the said Nanya Naika is the father of the plaintiff, whether grandfather of the defendant has to be decided.
So as of now, the properties, the plaintiff, no, please come to the appellate court, sorry. I have read the entire order.
Then not the appellate court also observed this thing. However, not the binding with that, not these records are insufficient, that is why not.
Let's go to that order.
Relevant portion is not 19, from below of 8, 9, case or after case, in order to prove the prima facie, case number 19,
No, still we read from para 14.
14. The defendant, on the other hand, produced the section register of the year 1966, in which serial number 3, the name of Hoskoti Karna Lambani Nanya Naika is mentioned as owner and the possessor of the social property. The resettlement register standing in the name of grandfather of the defendant, but in the RDC only Lambani Nanya Naika Nityapura is mentioned. As for the defendant, grandfather Hoskoti Karna Lambani Naika is also called Lambani Naika Nityapura. This fact can be decided only after the fulfillment trial. Whether the Hoskoti Karna Lambani Nanya Naika and Lambani
Naika Nityapura is
or not can be decided after full-fledged trial. And moreover, the settlement register produced by the defendant standing in the name of the grandfather of the defendant, Hoskoti Karna Lambani Nanya. The ROR produced by the plaintiff standing in the name of the person Nanya Naika Nityapura. Whether such Nanya Naika Nityapura is the grandfather of the plaintiff, this is not grandfather, father of the plaintiff, or not can be decided after full-fledged trial. Throughout the pleadings, the plaintiff nowhere stated his grandfather also called as Nanya Naika Nityapura. He specifically stated his grandfather's name is Lambani Nanya Naika, son of Naika. But this name is not mentioned in any of the revenue records of the individual property. Hence, from the pleading and documentary evidence, it is clear that because of similarity of the names of the grandfather of the plaintiff and the defendant, this confusion has been arised. This fact at this stage cannot be decided. There is a huge cloud on the title of the plaintiff over this mutual property. At this stage, evidence produced by the plaintiff are not sufficient to hold the plaintiff has made out the prima facie. In order to prove the prima facie case, these documentary evidence produced by the plaintiff are insufficient.
No, the court, at one place, court says whether whose father is who, whether it is the grandfather of yours or the father of the plaintiff, it has to be decided after a full-fledged trial. You come to page 19 bottom.
Page 19 bottom, my lords. Please, my lords.
Hence, balance of convenience also not.
Without observing these documents, the lower court has granted temporary injunction order holding that the resettlement register standing in the name of the plaintiff's grandfather. But in fact, the resettlement register produced by the defendant and the resettlement register standing in the name of the grandfather of the defendants, not in the name of the plaintiff's grandfather.
How can the court give court has given a finding saying
Please,
that.
my lords, there is a reason for that, my lords. Can I, my lords?
Yes.
My lords, because in the entire plaint, the appellate court has considered to their submission, that is, their grandfather name is Hoskoti Nanya Naika. That is nowhere reflected. But in my written statement, I have clearly stated, because my grandfather, for earning and other things, he had been to Nityapura village and he was working there. He was called as Nanya Nayak Nityapura. And that Nityapura from 1966 itself, from the RTCs, my lords, it is shown Nanya Nayaka Nityapura. But nowhere Hoskoti or some other thing which shows that the Nanya Nayaka shown in those RTCs, in the handwritten RTCs, belong to them. So recording that, my lords, so which clearly shows Nanya Nayaka Nicha Prand. There is one more document which I have produced before the trial court and before this honorable court, along with my statement of objection, my lords. There is my learned friend read one para from the trial court's order, my lords, where one more Nanya Nayaka was there, whose son Hari Nayaka had taken a loan without even getting this, the RTC changed in his name. He goes and takes a loan from the bank of 3,80,000. So when it came to our notice, this Ramanayaka, my father, the defendant Chandra Nayaka's father Ramanayaka, he files an issues an notice to the bank and says that see that we are not liable for that loan, and there is a manipulation or misrepresentation has been done, and we are not liable. If it was their property, if at all they believe that the survey number granted 3A/1 is their property, definitely they could have taken some action. Because somebody, some unknown person has taken loan in my grandfather's name. According to me, according to them, it is, if their property, their father's name. So why they said, why were they blank? Only on considering all these facts, my lords. And I kindly, my lords, my statement of objection may be kindly be looked into. In that, my lords, I have produced all the documents, my lords, which I am relying upon. My lords, way back from 1966, Annexure R1, my lords. It is in Telugu, my lords, where my entries are there. Survey number 3/1A, sorry, 3A at column number 3 and A, B, C, D, my lords, there. And after that, the handwritten.
Pagari Gonappa.
Please, my lords.
Why are you relying on 3?
My lords, what is granted to me is 5 acres 16 guntas in survey number 3/1A, my lords.
I am looking at Annexure R1.
Please, my lords.
Which serial number?
My lords, serial number 3, in that 3A is there, no, my lords, which is 7 acre 5 guntas, if I am not wrong, my lords, here. There, this is the, I will also produce kindly, if passover is been made. Today morning, I have received the original, I mean, a copy of the grant certificate, in where also it is clearly written that Lambani Nanya Nayaka Nichapura has been granted survey number 3A1, my lords, to an extent of 5 acres 16 guntas. That copy also I will produce, my lords, kindly further, my lords. So
No,
this.
no. What is this name that I am asking you?
My lord, this is resettlement register, my lord.
No, name is, where is your name? Your grandfather's name? It is just Kurubana Hali Bhima Pagari Gonappa.
My lord. Next, that is.
This Tapal list Chudumu. Kuruna Halli Gonappagari Basappa. That's not your name. Column number 3, your name is not there.
His father is alive, but he did not come before the court. And moreover, these are from Bekinamutti Tanda.
No, we are related. Say, even this the plaintiff is my relative.
No, let's see further. Where is your name?
My lords, kindly come to the page number 2, my lords. I think in there it is written in Kannada, my lords. Because this is in.
Page number 10.
What is the name written?
Nanya Nayaka, my lords. At, my lords, there are no numbers, but it is here, my lords. A, 3A.
What is the name?
Hosatti Tanda Lambani Nanya Nayaka.
So, as far as the revenue records are concerned,
Please,
that name, what is that last?
Nichapura, my lords.
Nityapura is not mentioned.
Nichapura is there in the very next document, my lords. Kindly see R2, my lords. R2 is the RTC, Pahani of the year 1965 to 1969, my lords. In that also, Nanya Nayaka is coming. And the very next document.
Nityapura, where is Nityapura?
My lords, it is in the next document, my lords, at R4, my lords. Nichapura, it is of the year 1983 and 84.
Where do you get that?
My lords, here, my lords. This is Nichapura.
Nanya Nayaka, Nityapura. Thereafter,
Nanya Nayak Nichapura, my lords, not Nagya Nayaka, Nanya Nayaka Nichapura.
now, in the next document also it is there.
Please, my lords. It is continued till 2015-16. In 2015-16, we go and approach the plaintiff.
You belong
Because
to
he
which
is,
village?
now I am residing at Bikemati. Bikemati.
What is his father's name not?
No, who has, I am in, the property has been divided now.
No, then what did you file to show that you are in possession of the property?
I have produced all the documents, my lords. Mahajar I have produced photographs.
Let us see.
R12, my lords. Kindly, I may be
No, let us-
permitted to refer
Let us
R,
see the cause title.
please, my lords.
Cause title of the revision, this petition.
Cause title of this petition, my lords. Please, my lords.
Chandra Naik, son of Rama Naik.
Please, my lord.
Sharda Bai, wife of late Kumar Naik. Who is Kumar Naik?
He is husband, my lords.
Whose husband?
Sharda Bai's husband.
Shanta Bai, very Shanta Bai.
Sharda Bai.
Sharda
R2.
Bai.
Ah,
No, Sharda Bai, how is related to you?
my sister, my lords.
Your sister.
Please, my lords.
Both of you are children of Rama Naik.
Please, my lords.
Then Rama Naik has a brother.
Please, my lords.
And Rama Naik's father is?
Rama Naik's father is Nanya Nayak, my lords, my grandfather.
But you have,
Nanya Nayaka's father is Megya Nayaka.
but you have made him only a party. But you have not made
Yes,
others
he has not
party.
made
That is-
entire.
It's for you to. You
That is
made
also
only
one of my
his name.
contention. My lords, kindly para number in my written statement, my lords. Kindly.
1 minute.
And this is the person who has not interfered in not the future of the property has been.
Which year is the suit?
2018. 18, my lords. And my lords, not even 1 inch the case has proceeded.
Person was created not, persons interfered not since not. Yes,
Kindly, my lords, my lords, since time immemorial, we are cultivating. Now they are interfering with our property.
We'll do one thing.
Please, my lords.
For this interlocutory application with regard to this, who is in, as per the RTC extract, so and so his person is in.
No, my lords, that will create multiplicity of the cases, my lord. My lords, the reason is, my lords, from time immemorial, my lords. My lords, I am producing the register, my lords.
That's
The
why-
revenue authority itself has drawn a mahajar.
That's why we will say, we'll give an opportunity to both of you, let him also produce the
Please, my
family
lords.
tree and all other details
Please,
with
my
regard to the family and other details. You also produce.
Please,
Let
my
the court decide.
Yes, my lords. Yes, my lords.
Court
A
decide.
date may be fixed, my lords, to that effect. My lords, it is all from 2015, my lords.
Where did you buy file?
Page number. Page number 36.
30?
36. So it is for the year 2015. 36 months.
My lords, it is a disputable document, my lords. They have to prove it. They have to prove it in the trial because this person,
From 2015 to?
2019.
my lords, that is when,
Before that?
Before that, not the uneducated not. Even they did not inform to the not the authorities on.
And now, from your side,
Please,
apart
ma'am.
from the RTC extract, what is the other document?
my lords,
which
I
you-
have the original grant certificate in my favor, my lords. In my hand, my lords. I can produce that, my lords. I will produce the original grant certificate in where which is clearly written that the land is granted to Nanya Nayak Nichapura. I have the document, my lords.
Produce.
I will produce it, my lords. And a date may be fixed, my lords.
This is matter on 22nd.
Much obliged. Much obliged.
The request of.
That question may arise. Sir, this Nanya not belong to his family.
I will.
You're not having that original
Let him produce if he has, my lords.
is saying a
Sagoli cheat.
document,
Here it is called as Sagoli cheat, my lords.
No, what we'll do is let him produce, then I'll remand this matter. Let the court decide basing on these documents.
Please,
For the satisfaction of the court, let it be shown.
please, my lords. Illa. The problem is, my lords,
The
the
Lord
balance
Deva-
is convenience is in my favor and he wants to interfere and
Yes.
dispossess us. Much obliged.
Yes.
Ganesh Kumar K for petitioner 49.
Yes.
Please, ma'am. For the respondent.
Hmm. After the stage of that mic, you please set that left mic is not.
Yes, my lords.
Hmm.
At the stage of arguments are made, my lordship. He filed application for amendment of plaint, my lordship.
You are the plaintiff.
I am for the defendant number 1.
Plaintiff has.
Plaintiff has filed.
Please of which year?
Term 4, my lordship.
2004. When is the IA?
5/8/2019, my lordship.
5/8/2019.
Yes, my lordship.
Hmm.
So
It is allowed.
it is allowed, my lordship.
Come to the impugned order.
My lordship, the 40, my lordship. Page number 40, 41, 41. Kindly come to page number 32, my lordship. I applicate.
Para number 8, please read.
Having heard on perusal of the materials on record, it is noticed that at present the suit is set down for arguments on main, and now the present application is filed. The learned counsel for the plaintiff submitted that the plaintiff during the pendency of the suit sold property out of 12.5 guntas and restricted to the suit property to an extent of 3 guntas, which is encroached by the defendants. In the view of amendment of suit property, the present amendment is only explanation of facts. When only 3 guntas is available, then the words on the western side is of no consequence. The learned counsel for the defendant submitted that in the entire plaint pleadings mentioned in respect of western side of the suit property, the parties have also led their evidence based on such pleadings and defense. Now, if the same is amended, it is nothing but withdrawing of admissions already made. Hence, the C is not permissible. My lordship, they are claiming earlier, my lordship, the property.
When did he sold the property?
My lordship, I purchased the property in the 1992, my lordship. Sold.
When did this property is sold? That 12 acres of land?
2018, I guess.
Huh?
2018. After the property is sold, he's made an application
Now
for.
you
No,
want only
Please.
the boundaries are going to be changed by
Change.
virtue of this.
Please, my lord.
Please come to that order.
Lordship. Page.
Come to that IA.
Please. Lord, annexure D, your lordship may kindly see the application. For the reasons set out in the accompanying affidavit in the IA, applicant or plaintiff in the above case most humbly pray that this honorable court be pleased to permit him to amend the plaint as sought hereunder in the above case, as it is quite essential in the interest of justice and equity. Amendment sought for A. In the plaint B prayer, at 5th line, after the word guntas, delete on the western side of, and in its place add which is. And at line number 11, delete the western side of.
Now, please come to the objections filed by them.
Please, my lord. The facts of the case is that
What is your objection?
My lordship. So, initial, my lordship, they claimed 12.5 guntas, my lordship, initial short. Then he sold the property in that 10. Kindly.
Not
pay-
10, he says 19.
No,
Eight.
no, 10. Kindly see the plaint, my
Paint
lordship.
is restricted only
Page-
to 3 guntas,
one
which
minute,
they
one-
have encroached upon.
1 minute.
The total measurement
Ah.
was 12.5 guntas. Originally, the total measurement was 12.5 guntas. I have filed plaint restricting my claim only to 3 guntas, which is encroached upon. So 12.5 guntas, 3 guntas, where is encroached was on the western side of my total 12.5 guntas. After 9 guntas, 9.5 towards the western side, 3 guntas he had encroached. Pendency of the suit, that 9 guntas, 9.5 guntas, the respondent has sold it. So now what remains is only the 3 guntas which is encroached upon. So in the prayer, it is shown as 3 guntas to the western side of my property. So totally 12.5 guntas, 3 guntas to the western side. So once the property is already sold, the remaining side, so that western side doesn't make any sense now. So he wants to make an amendment saying that only 3 guntas in survey number so and so, which is encroached upon. That is all the amendment is not. The plaint is already amendment. Only in the prayer column, it has to be amended.
My lordship is plaint, my lordship, page number 14, my lordship.
When the court has permitted them to amend the pleadings,
Yes, ma'am.
what has not been done is, in consonance with that, the boundary should be amended.
In the prayer.
My
Boundary
lordship.
should be amended.
Yes, madam. I agree, my lordship. Kindly page number 14, my lordship, plaint, in para number 8A, my lordship. The plaintiff by retaining the suitable property, that is western 3 guntas, which is shown in the red color in the annexed rough sketch out of the land measuring 12.5 guntas. He has sold the remaining land in the said 12.5 guntas towards the western side of eastern side for these legal necessities in favor of Muhammad Hanif, Shantama and Baswaraju through the 3 different registered sale deeds dated 29/9/2010. During the pendency of the suit, put them into possession of their respective properties as per their sale deed. In the sale deed of Muhammad Hanif, the western boundary is mentioned as Pujita Lodge of defendant. So the Pujita Lodge, that.
Please look at your objections. These are all not your objections.
No, my lordship, that is the main.
Look at the objection.
The,
I'm looking at,
if the amendment is allowed, my lordship, it will change the location of the property, my lordship.
look at the objections.
Ah,
Where
ma'am.
did you say so?
Yes, ma'am. Yes, ma'am.
Tell that one single amendment.
My page number 38, my lordship.
Yes, I'm looking at it.
The words the plaintiff wants to delete comprises material and substantial facts which require adjudication. The plaintiff has replayed the same facts in his plaint. Cross-examination has been conducted on those facts and some rights have been accrued to this defendant. The plaintiff intentionally withdraw the rights.
Here there is nothing to withdraw. The fact is,
Yes,
the
madam.
property is mentioned. Because this property is his property.
Yes.
He said western side. No, this property is already sold.
Sold.
What remains is only 3.5. With regard to this, already an amendment was filed. That was allowed. It is a consequential amount. It should have been part of it. No, more or less, it is a consequential to that. When once you have no objection for that, this has to follow. No, a property which was a large extent of 12.5 can't be, the boundaries will not be the same when you sell 9 acres of land. Please come. Where is the impugned order page number?
Page number 40, my lordship.
Annexure F.
Yep. 41.
Agreed with orders passed from, no IA.
No IA number is given.
Agreed with the orders passed on an IA under order 6 rule 17 CPC. Invoice number 19 of 2004, dated 5/8/2019. The defendant is before this court. The plaintiff had filed the suit. What is seeking the declaration?
Declaration, mandatory injunction and possession. And possession also.
Declaration, recovery of possession, and a consequential
Release.
declaration, recovery of possession, and a consequentially a mandatory injunction. It is his case that he is a owner of an extent of 12 acres, 12.5 acres.
12.5 guntas, my lord.
12.5 guntas, his owner, it is the case of the plaintiff that he is absolute owner of an extent of 12.5 guntas in survey number 48/6. And the suit is, and out of which 3 guntas is encroached by the defendant. During the pendency of the suit, he had sold 3 guntas of land. How much? 9
Nine-
guntas of?
9.5, my lord, 9.5.
Half guntas of land, and the remaining is 3 guntas. In this regard, earlier he has filed an IA seeking amendment, and the said amendment was allowed. Now, he has filed the present IA seeking amendment with regard to the boundaries in view of the sale of 9.5 guntas of land. That IA came to be allowed by the trial court by way of the order imputed. The court observes that the proposed amendment is not inconsistent with the claim of the plaintiff. The proposed amendment will only clarify the nature and it will not change the nature of the suit and cause of action. The proposed amendment is very much required for adjudication of the dispute on hand, and it will not have inconsistence. It will not be inconsistent with the pleading of the parties. If the amendment is allowed, no hardship will be caused to the defendants, and no admission will be taken away. Therefore, the court has allowed the amendment. Aggrieved thereby, the defendant is before this court. Then comes the petitioner, the petitioner defendant submits that at the fag end of the trial, the court ought not to have allowed an application. It virtually amounts to taking away that certain valuable rights accrued in favor of the defendant, and also the certain admissions already made by the plaintiff. It is submitted that after the commencement of the trial, if the defendant, if the plaintiff wants to amend the plaint, he has to specifically state about the due diligence, whereas in this case, no such amendments are made. In spite of that, the court has allowed the application. Next paragraph. Land counsel appearing for the respondent plaintiff submits that the amendment that is sought, by way of the amendment, the plaintiff is not putting forth any new case, nor he is trying to take away the defense or improve his case. In fact, the amendment that is sought by him were to delete an extent of 9.5 cents of land is already 9.5 guntas of land is already allowed by the court. And once that is allowed, even in the plaint, the boundaries should be altered, amended as per the same, which was not done. And when an application is filed by them, the court had rightly allowed the application and no grounds are made out, seeking interference with the well-considered order passed by the court. Next paragraph. Having heard the counsels on either side, there is some material on record. When an application is filed under Order 6, Rule 17, after commencement of the trial, it's the burden of the party to satisfy the court that that in spite of due diligence, they could not bring the amendment to the notice of the court. Then the court has to look into the prejudice that ought to be caused to the defendant, and also whether by virtue of this amendment, the plaintiff is putting any inconsistent pleas, or is trying to fill up the latches by this amendment. In this case, already the earlier amendment is allowed, and wherein instead of showing that he is an owner of 12.5 guntas of land, now according to him is only a owner of 3 acres, 3 guntas of land. 3 guntas of land, and that is allowed. Now, unless and until this amendment is done, it would be difficult for the court to adjudicate the dispute between the parties as when it is an extent of 12.5 guntas and when it is 3 guntas, the boundaries would change and it has to be specific, it needs to be amended and brought to the notice of the court. In that view of the matter, this court finds no reasons to interfere.
Liberty may be given, my lordship, to cross-examine.
Accordingly, 1 minute, accordingly dismissed, yes.
So liberty may be given to the defendant to cross-examine the plaintiff on this issue, my lordship. Suppose if a plaintiff didn't plead a further evidence, so I could not be permitted to cross-examine.
If he has any further evidence, then you will be.
Please. Please, no.
The petitioner, if the plaintiff adduces any further evidence, the defendant is at liberty to
No,
cross-examine.
even suppose he is not lead a further evidence, so I have to cross-examine on this issue, my lordship.
There is no need.
There is no issue at all.
There is no, there is no fresh or new
Needed, my
issue.
lordship.
Huh?
No, it is needed, my lordship.
I didn't get you.
No, suppose he is not lead further evidence, my lord, have to cross-examine the plaintiff, my lordship.
Already this issue of 3.5,
Earlier, my lordship,
that is done.
Yes,
When
my
it is
lord.
done, it is done, not required. If the same thing, if the petitioner is, if the plaintiff is permitted to adduce any evidence, further evidence, the defendant is at liberty to cross-examine him. Yes.
And the time limit
Time,
may
my
be
lord.
framed, my lord.
Which year is this?
2004, my lordship.
This is a matter of 2004. And it's pending from the last, it's a matter of 20 years. The court should dispose of the same as expeditiously as possible, but not later than 1 year.
1 year.
1 year.
That is-
Before that, they can't do,
Please,
because there are so many cases. Even if I tell again, they'll come up with a requisition.
requisition.
6 months enough, my lordship.
Huh?
6 months is enough.
What is the stage now?
Arguments, my lordship.
Arguments.
Arguments,
6 months, but not later than 6 months.
problem.
Much of it.
ಮೇಲೆ ಫೈಲ್ ಕೊಟ್ಟ ತಕ್ಷಣನೇ ಸೀರಿಯಲ್ ನಂಬರ್ಸ್ ಎಲ್ಲ ವೆರಿಫೈ ಮಾಡ್ಕೊಡಿ ಅಂತ ಹೇಳ್ತೀನಿ. ಗೊತ್ತಾಯ್ತಾ? ಎಲ್ಲಾ ಕಡೆ ಹುಡ್ಕಿದಾಯ್ತು. ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಹುಡ್ಕಿಸಿದಾಯ್ತು. ನೀನ್ ಹೇಳ್ಬಿಡ ನೆಕ್ಸ್ಟ್ ನಾನು ಹೇಳಿದ್ದೀನಿ ಇವಾಗ ನೀವ್ ಯಾವ ಫೈಲ್ ಇಲ್ಲ ಅನ್ನೋ ನಾನು ತಲೆ ಕೆಡ್ಸ್ಕೊಳ್ಳೋದಿಲ್ಲ. ನಿಮ್ ಜವಾಬ್ದಾರಿ ಅದು ಫೈಲ್ ತಗೊಂಡು ಹೋದ್ಮೇಲೆ ನಿಮ್ಗೆ ಬಂತಾ ಇಲ್ವಾ ಅಂತ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಯಾವ ಫೈಲ್ ಇಲ್ಲ ಅಂತ ನಾನು ನಿಮ್ ಕಿವಿನೂ ಕೇಳಿಸ್ಕೊಳಲ್ಲ ಅಂತ. ಇದು ಎಷ್ಟು ಸತಿ ನಮ್ಗೆ ಎಂಬ್ರಾಸ್ಮೆಂಟ್ ಮಾಡಿರೋದು ಅವರು ಫೈಲ್ ಇಟ್ಕೊಂಡು ಅವ್ರ ಹತ್ರನೇ
ಟೈಪಿಷನ್ ಮಾಡಿರೋದು ಅವರು ಬಂದ್ಮೇಲೆ ಬೈದೆ ನಾನು ಹೇಳಿದೆ ಅರ್ಧ ಗಂಟೆಯಿಂದ ಬಿಲ್ ನೋಡಿದೀವಿ ಅಂತ
ಹುಡುಕ್ರಿ ಎಲ್ಲಾ ಫೈಲ್ಸ್ ಹುಡುಕ್ರಿ ಬೀರುನಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾನೆ ಇದೀನಿ. ಹುಡುಕುದ್ವಿ ಅಂತ ಸುಮ್ನೆ ಹೇಳ್ತಾ ನಮ್ಗೆ ಇಲ್ಲಿ ನಾಳೆ ಬೇರೆ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಏನೋ ಇನ್ನು ಟೈಮ್ ಇದೆ ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಎಷ್ಟು ಎಂಬ್ರಾಸ್ಮೆಂಟ್
ನಾಳೆ ಡೇಟ್ ಇದೆ.
ರಿಪೀಟ್ ಕೊಟ್ಬಿಡೋಣ ಕೊಡೋದು
ಇದೇನಿಲ್ಲ ಮೇಡಮ್.
ಅದೇನ ಅದಕ್ಕೆ ಹೇಳಿದೀನಿ. ಇನ್ಮೇಲೆ ಏನ್ ಫೈಲ್ ಇಲ್ಲ ಅಂದ್ರೆ ಸುಮ್ನೆ ಕೇಳಿಸ್ಕೊಬೇಡ ಬಂದ್ಬಿಡ ಅಷ್ಟೇ. ಯಾರು ಟೈಪಿಸ್ಟ್ ಬೀರಿಗೆ ಯಾರು ಹಾಕಿದ್ದು ಫೈಲ್ ಅವ್ರದ್ದು ಬಿಂಜೆ ಅದು
ಏನಾಗಿದೆ ಬೆಳಿಗ್ಗೆ ತಗೋಕೊಟ್ನಲ್ಲ ನೋಡಿ ಡೇಟ್ ಅಂತ ಅವಾಗ ಏನೋ ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಬಿಟ್ಟವ್ರೆ ಅವರು ಬೇರೆ ಒಳಗೆ 3 ಫೈಲ್ ಹಾಕ್ಬಿಟ್ಟವ್ರೆ. ನಾನೇನ್ ಅನ್ಕೊಂಡೆ ಗೊತ್ತಾ ಈಗ ಮಧ್ಯಾಹ್ನ ತಗೋಗಿದ್ದಲ್ಲ
ಫೋನ್ ಮಾಡಿ ನಂಗೆ ಹೆಸರು ಹೇಳಿದ್ದೀನಿ.
ಈ ಹುಡುಗಿಗೆ ಗೊತ್ತಾಯ್ತು ನಾವೇನೋ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಗೊತ್ತಾಯ್ತು.